Good morning, distinguished guests, keynote speaker, and Zoom meeting participants. Welcome to Universitas Kristen Indonesia Postgraduate Program. Honorable Director of Universitas Kristen Indonesia, Dr. Daniswara Kaharyono, SHMH MBA, Vice Rector for Academic Affairs and Innovation, Dr. Hulman Panjaitan, SHMH, Vice Rector for Finance, Marketing, and General Affairs, Dr. Juanifa J. Sidarta, SAMSI, Vice Rector for Students Affairs, Alumni, and on Cooperation, Dr. Erpol Iyat Vedasi Tepu, SSMA, Vice Rector for Human Resources and Legal Affairs, Dr. Lisa Gracia Kailola, SSMPD, Director of Postgraduate Program, Professor Dr. Bernadetta Nadiak, MPD, PA, Vice Director of Postgraduate Program, Desi Sianipar, MTH, DTH. Also, Our Excellency, distinguished guests from Argentina, Nigeria, Pakistan, Sri Lanka, and Kerala, India. I am Catherine Monica, a Master of Ceremony for today's event. Welcome to International Conference, Human Rights and Human Dignity, in commemoration of International Human Rights Day of Universitas Kristen Indonesia, Master of Law Program. Ladies and gentlemen, we would like to start this program with the prayer. I would like to invite Conrad Manurung to lead us in the opening prayer.
Mari kita berdoa. Bapa di surga yang kami sembah di dalam nama Yesus. Sungguh kami bersyukur dan berterima kasih pada pagi hari ini Tuhan, atas kesehatan, kekuatan, dan kesempatan yang indah ini. Pada pagi hari ini akan terlaksana acara seminar International Human Rights Conference in Commemoration of Human Rights Day. Kesempatan yang indah ini Tuhan, biarlah Engkau yang berkati pelaksanaan seminar ini, agar segalanya terlaksana dengan baik. Biarlah kami semua yang ada di ruangan ini dan yang ada di Zoom bisa terlaksana dengan baik Tuhan. Berkati juga para speaker atau narasumber dari negara Argentina, Nigeria, Pakistan, Sri Lanka, India, dan Indonesia. Berkati juga pimpinan rapat pada pagi hari ini, para moderator yang memimpin jalannya acara. Segalanya kami serahkan ke dalam tangan-Mu Tuhan. Pada kesempatan yang indah ini, kami bersama-sama. Kami akan mendapatkan ilmu yang sangat besar yang dari Engkau Tuhan. Kami berdoa supaya Engkau memberkati juga seluruh dosen UKI yang dengan senang hati memberikan kami ilmu pengetahuan yang berasal dari Engkau. Sehingga Universitas Kristen Indonesia ini yang kami cintai ini Tuhan, semakin besar, semakin hebat, semakin diberkati. Berkati juga kami para mahasiswa, peserta seminar juga panitia. Seluruh mahasiswa yang ada di Universitas Kristen Indonesia kami serahkan ke dalam tangan-Mu. Kedamaian yang dari Engkau dan kuasa yang dari Engkau selalu mengikuti kami Tuhan. Dan satuan hati kami untuk memberikan yang terbaik untuk negara ini. Biarlah kami menjadi mahasiswa yang dapat memberikan perubahan dalam negara ini ke arah yang lebih baik. Bapa, banyak kekurangan kami di kehidupan kami Tuhan. Hanya Engkau yang sempurna. Oleh karena itu kami berdoa, kami meminta supaya Engkau tetap memberikan kami Tuhan kuasa-Mu, supaya kami mendapatkan perolehan ilmu yang sangat besar, ilmu yang sangat baik, yang kami akan dapatkan dari universitas kami tercinta ini. Kami serahkan para dosen-dosen kami yang sangat luar biasa ini kepada kami Tuhan, yang dengan senang hati memberikan kami ilmu yang sangat besar ini. Kesempatan yang indah ini tidak akan terulang dua kali, tapi akan lebih baik. Dan lebih baik, dan lebih baik. Kami serahkan acara dari permulaan, pertengahan, sampai akhirnya nantinya. Jauhkan kami dari segala hambatan-hambatan Tuhan. Biarlah Engkau memberikan kuasa-Mu kepada seluruh kami peserta yang hadir pada saat ini dalam ruangan dan dalam Zoom. Kami percaya, kami yakin akan segala kebaikan-Mu Tuhan Engkau limpahkan kepada kami. Kami serahkan acara ini ke dalam tangan Tuhan. Terima kasih atas berkat dan karunia-Mu yang sangat besar. Kami serahkan tubuh, roh, dan jiwa kami ke dalam tangan-Mu. Melalui anak-Mu, Yesus Kristus, Tuhan kami berdoa dan mengucap syukur. Amin.
Okay, thank you, Mr. Conrad Manurung, for opening prayer. Now we are going to sing our national anthem followed by Mars Uki. Ladies and gentlemen, please stand up in the formal and respectful position.
Universitas Kristen Indonesia, universitas kita, pelambang ilmu dan budaya bangsa, turut membina pendidikan kita, bergerak maju membangun alam semesta, bekerja penuh kasih dan bakti, melayani bukan dilayani, abdi nusa dan bangsa. Universitas Kristen Indonesia, universitas kita, pelambang ilmu dan budaya bangsa, turut membina pendidikan kita, dan kami mahasiswa-mahasiswinya bersama mengajar ilmu dan cita-cita, mengabdi membina nusa negeri kita yang jaya.
Okay, for ladies and gentlemen, please sit down. Ladies and gentlemen, to officially this event, we will listen to the opening remarks from our Director of Postgraduate Program, Professor Dr. Bernadetta Nadiak, MPDPA. For Professor Dr. Bernadetta, the floor is yours.
Okay, thank you, Catherine. Honorable Rector of Universitas Kristen Indonesia, Dr. Daniswara Kaharyono SH MBA, Vice Rector for Academic Affairs and Innovation, Dr. Hulman Panjaitan, Vice Rector for Finance, Marketing and General Affairs, Dr. Joni Fasidarta MSc, Vice Rector for Students Affairs and Cooperation, Dr. Rer Paul Edvida Sitepu, SSMA, Vice Rector of Human Resources and Legal Affairs, Dr. Lisa Kelola Esos MA, Dean of Universitas Kristen Indonesia, and Head of Postgraduate Study Program. Also our keynote speaker from Argentina, from Pakistan, from Sri Lanka, from India, Kerala, and from Nigeria, and from Universitas Kristen Indonesia. Lecturers and students of Universitas Kristen Indonesia, distinguished guests. Good morning. Welcome to Indonesia Christian University Postgraduate Program. We proudly present our international conference, International Conference Human Rights and Human Dignity, held by Master of Law Postgraduate Program and the Christian University of Indonesia. This is our annual event. Today is our second meeting since 2021. Currently, the postgraduate program of UKI has 8 study programs consisting of 2 doctoral study programs, which are Law and Christian Religious Education, as well as 6 master's degree study programs, which are Management, Christian Religious Education, Law Education, Administration Education, Architecture, and Electrical Engineering, with more than 700 students. Human rights and the concept of human dignity are inextricably linked. The two concepts are inextricably linked because of the comprehension of the terms with each other. The concept of human dignity underlines the importance of human rights and the obligation to respect the rights of all. In this case, human dignity is seen as foundation of human rights. Human dignity is applied by human rights advocates and a variety of social movements to demonstrate their statement and action. Human dignity concerns a fight against global poverty, the conflict against discrimination, violence, and punishment in justice. The central of human dignity leads to the question of its justification. Where does the power of human dignity come from? Or rather, why does a person have a dignity that justifies the need to respect his rights? The answer of the questions depend on the perspective of someone who is speaking, which is relatable to the point of view of a religious, philosophical, and experiential point of view. After this conference, we will explore this different perspective, understanding the relationship between human rights and human dignity, allow us to understand more about humanization of human beings and the world we live in. Finally, postgraduate from program would like to thank all of the speakers today. Once again, welcome to the International Conference of Human Rights and Human Dignity. Thank you very much, and may God bless all of us. Thank you.
Ladies and gentlemen, now the International Conference Human Rights and Human Dignity have officially begun. Give a round of applause for today's event. Now we have come to the main agenda. During this session, we will hear a various presentation and then delivered from our keynote speakers. May I remind you for Zoom meeting participants to mute your mic speaker when you are unmuted, and then open your camera and use our virtual background that committee that have give to you all. So our section will be divided into the 2 sections. The first section will be moderated by Dr. Bluserwe Rajakuguk from Universitas Kristen Indonesia, and the second section will be moderated by Dr. Manotar Tampu Bolon. SH, MH, MH. I will read the bio note of our moderator. Dr. Bluserwe Rajaguguk is a head of the main Directorate of Legal Development of the Audit Board of the Republic of Indonesia. His educational background and his interest in law and accountant led him to certify of the various certified, such as the management, forensic auditor, and then public accountant. For Mr. Bluser, can you hear me? Are you audible for this meeting, Mr. Bluser?
Okay.
Okay. Mr. Bluser, the
Sure.
floor is yours.
Thank you, MC. Good night, all the distinguished speakers. I think it's almost midnight in Buenos Aires now, yeah. And also all distinguished participants, all the lecturers and students today. I will moderate 4 speakers in this first session, and each speakers will speak about like 15 minutes for the presentation. And our first speakers will begin by Prof Farinella, yeah, with the title Human Rights When Dignity Meets Technology. And second speakers will be present by Prof Sofia Del Carril. Is he here? I'm not seeing Professor Carril.
Sorry, Mr. Blusor, she's having some problems with electricity at his home.
All right, okay.
She's trying to solve it.
All right, okay. So I think we can manage that. And I think it will be followed by Prof Mariano De Rosa. Again, congratulations for your team for the semifinal. He will talk about the Inter-American Court of Human Rights and its jurisdiction. And in my session will be speak by Prof Romina Manizo. She will speak about challenges for a culture of human rights in the information communication technology context, the 4th generation. So, ladies and gentlemen, I think these 4 presentations are very interesting because we will be show how the relation between the human rights and also the dignity and also the information communication technology. Yeah. So I think this is a new subject that we rarely heard about, and I think it's a very interesting to be heard after this session. And after the 4th session will be we will open the questions and answer session. It's about 30 minutes. So that's the schedule. So for the first speaker, Prof Aurinella, I will give a brief curriculum vitae about him. Now he currently works as a director of the Research Center of International Law in Mar del Plata National University, Buenos Aires, Argentina. He also coordinates research project and teaches 2 subjects, public international law and human rights. And I think he got his PhD in law with summa cum laude. I think that's the brief so this is your presentation will be 15 minutes. Please, Prof. Fabio.
Dear Professor Blusser, thank you very much. I'm going to share, if I let a presentation that I have prepared. I'm trying, but I'm not allowed up to now. Yes.
Okay. All right. Share screen.
Please let me know if it's okay. You can see it.
Yeah, we can see that.
Okay. Thank you very much. Well, good morning again to you all. Thank you very much for the kind invitation I received to be part of this conference commemorating the 74th anniversary of the Universal Declaration of Human Rights. Thank you very much to Professor Dr. Bernadetta Nadiak, Professor Vivek Srividyarthi, and of course our moderator Blusser Raya Guguk and Professor Manotar Champuvolon, and of course the authorities and students of the Christian University. When I was invited, I had to think some minutes about the topic I was going to deal with, and I want to talk about the past, because this is a commemoration of the 74th anniversary, but I also want to talk about the future. So I needed to link the dignity as a value, which is something like the foundation of human rights after the Second World War, but I will also talk about the technology, and especially neurotechnology, that by one way or another will change our perspective of human rights. And this is the result. I hope you like it. My whole presentation will spin around a basic idea that states that human dignity should be understood as a normative concept for the regulation of technologies. In the time I have, I will share three main ideas. The first one is that we need to consider human dignity as something like a foundation, a cornerstone of any human rights regime, a core value of the system. The second idea is that we have to assume that we live in a time of major global and environmental challenges, as well as the increasing replacement of human action and thought by technology. It can adopt any form, such as artificial intelligence, biased algorithms, neurotechnology, automation, etc. And the third idea I'm going to discuss is that in this context that I mentioned, human dignity takes on the role of guiding the development of a technology-responsive human rights regime. The first one, we start. Human dignity is an absolute value. And with this, I'm going to mention that it mustn't allow for derogations when that value is translated into rules. In this regards, I'm going to mention two philosophers from very different cultural backgrounds. One mentioned from ancient China. He's one of the most important classical Confucianists, and Kant, which I think we all know from modern Europe. Menjo was the only one who came close to an absolute concept of individual dignity in the century 4th before Christ. This absolute value is expressed in his constant emphasis on the immanent goodness of human nature. He expressed that minds that feel compassion, shame, respect, and correctness are common to all human beings. According to Kant, the human being, and in general, every rational being, exist as an end in itself. This means that the rights to human dignity is absolute. Hence, no derogation is admitted. If the first step was to consider the value of dignity as a principle which guides human rights interpretation, the second step would be its recognition under international conventional law. And at this point, it's important to mention that modern constitutions, such as the Virginia Bill of Rights in the States of 1776, and the French Déclaration des droits de l'homme et du citoyen of 1789, initially mentioned human rights, but not human dignity. Only since the 1945 UN Charter and the 1948 Universal Declaration of Human Rights has human dignity been established alongside human rights. The UN Charter affirmed in its preamble the dignity and value of the human person. And the Universal Declaration that we are commemorating today, in Article 1, recognizes that all human beings are born free and equal in dignity and rights. As regards domestic laws, following World War II, and as a result of its inclusion in the instruments mentioned, human dignity became a central concept in contemporary constitutionalism. Before 1945, only 5 countries used the term in the constitutions. In this century, and after the Second World War, more than 162 states in their constitutions did so. Anyhow, the foundations of human dignity in the legal provisions of states are neither clearly nor consensually determined. Argentina, our country, in its constitutions recognizes something like a right to human dignity, I could say only indirectly, because it doesn't appear in the first part of our constitution, which includes declarations, rights, and guarantees, but in the second part, when dealing with the incorporations of international human rights treaties. Article 75, paragraph 22 of our Argentine constitutions enshrines relevant international instruments on human rights, making them prevail over domestic laws and over other international treaties. They are part of what we call the block of constitutionality. Among these instruments, the American Convention of Human Rights expressed that every person has the right to have their dignity recognized. The second idea to discuss refers to technology challenges, and especially the one that comes from neurotechnology. Asking, this is the big question, if there will be a need for stating and adopting new human rights. In the near future, technology applied to neuroscience may allow third parties to access our thoughts and manipulate our memory. There are some authors that some years ago started talking about the creation of memories by the social media. The way we remember things is different now than it was 10 or 20 years before. Here we come to neurotechnology, which encompasses any method or device in which electronics interface with our nervous system to monitor or modulate neural activity. Although regulation of neurotechnologies appear to be unnecessary at the moment, the question becomes, I think, it's relevant to talk about it because when it will be possible to map a modified human brain activity, or for instance, when we link neurotechnology with artificial intelligence, and a machine can decide when and who to kill, like in the case of lethal autonomous weapon systems, the so-called killer robots. There's a world campaign to stop killer robots nowadays. The future applications of neurotechnologies will affect not only our way of life, the way we live, but also the very nature of what we now consider, or what up to now we consider to be human. The intersections between neurotechnology and law generates nowadays a very, very new field called, a very interesting field to research upon, called neurolaw. Some years ago, there was a proposal. It was made by a Spanish neuroscientist, Rafael Juste, and his group of researchers. There was a proposal to affirm entirely new human rights based on neurotechnologies. They are known as neuro rights, and we will just briefly discuss them. Here in this slide, I mentioned the command that comes from each of the eventual new rights: cognitive freedom, mental privacy, mental integrity, and psychological continuity. In the sense that I equate each right with a prohibition. The first one, cognitive freedom, is the right, or would be the right, of each individual to think independently and autonomously, to use our full spectrum of our mind and to engage in multiple modes of thought. Here, the prohibition would be, you are not allowed, you're not talking about the society. The society is not allowed to enter my mind without my consent. The second one, mental privacy, would protect individuals against unauthorized third-party intrusion into our brain data, preventing the unauthorized collection and leakage of such data. And the prohibition will be, you are not allowed to enter or collect my brain data. The third one, the right to mental integrity, will grant specific protection against intervention enabled by neurotechnology that involve an unauthorized alteration of our nervous system, causing harm. Here, the prohibition will be, you are not allowed to manipulate my neural activity. And the fourth and final one, the right to psychological continuity, intends to preserve the personal identity and the continuity of the mental life against possible alterations carried out by third parties without the consent of the person. And we finally come to the last of these three ideas, the one that postulates that in the context that we have been described up to now, the role of human dignity should be to guide the development of technology in order to protect and promote human rights. I just share two slides with some statistics, because in this century we are witnessing the birth and development of someone like we can call the Homo technologicus, who is any individual determined and shaped by technology. This is a proof of this. We are exchanging ideas and lecturing and doing things at a distance, but we are almost all day long connected. Here is the statistics of last year, the daily time spent with media. The average, the world average is 7 hours, and it was increasing in the last 10 years, increasing about 20 minutes per year. And the spend watching television, broadcast and streaming, 3 hours, 20 minutes. This is the average. Later, we will see that in Argentina and in Indonesia, we exceed that average. Or the time used in social media, 2.5 hours. In this second slide, we can see here we are, Argentina, it's almost 9 hours and 40 minutes. We exceed by 2 hours and more the average of the world. And here we find very close Indonesia with 8 hours and 36 minutes using internet. I mean, if we take 8 hours to sleep, it's half of our conscious day using internet, half the day using internet. If not, it's a third. This data can make easy to understand that we as humans we as students or professors or researchers write, we learn, we think, we remember things in new ways, not known before. Some authors call this the technological gaze, the technological look. And this means that people conceptualize nature, including human beings, including us, as simple raw material. Nature is viewed as inert matter, something devoid of any inner purpose, inner structure, just to be manipulated according to the whims of the powerful. Coming to the perspective, we should remember that without humans, there will never be human dignity. And maybe doing nothing in the face of the technological revolution swirling around us is to accept something like the abolition of man. Just to remember a title of a book written 80 years before, we talked about more or less the same. But at that time, it was a dystopia. Now it's a reality. The answer we still have to elaborate refers to what will be to be human in the technological future we are leading to. In this 74th anniversary of the Universal Declaration of Human Rights, maybe we can propose two directives. The first one would say something like, no human dignity without humans. And the second one would say something like, no technological development if it doesn't take into account the inherent dignity of any man and woman. I'm really deeply honored to be able to share some brief remarks on dignity and technology. And thank you very much for your kind invitation. Thank you.
Thank you, Prof. Fabio. You're very accurate. Exactly 15 minutes. A very interesting, I think, very interesting view that you speak just now. Distinguished speakers, ladies and gentlemen, I think we all just heard the presentation of Prof. Fabio. So allow me to summarize some points. I think it's very interesting when Prof. Fabio correlate between the dignity as a core value, yeah, of human rights, as the foundation of human rights, and then comes the neuroscience or what we call neuro rights. Yeah, it emerged a neuro rights because of a neuroscience. The question is this a new human rights or not? And I think it's a very fundamental questions, because we all know that so many hawks, yeah, we face today, we deal today. It is very relevant, I think, that the neuroscience can manipulate our neural activity. That's very interesting. Now, please, I think let's we go to the second speaker, because Prof. Sophia Carol's still not here. I think we can pass to Prof. Mariano de Rosa. Prof. Mariano de Rosa. He's a professor of international law. Yeah, international law. Let me read your CV a little bit. Prof. Mariano Rosa, full-time student at Instituto del Nacional Foreign Service Institute, right? The technical body of the Argentine government, whose main function is to recruit and professionally train Argentine diplomatic officials. Yeah, it's a diplomatic official. He also a lawyer, graduated from University of Mar del Plata. Master in International Study, currently PhD candidate at University Torquato de Tella. He is a professor of international law and researchers at the University of Mar del Plata in the Center of International Law and Regional Integration. And he will speak about the Inter-American Court of Human Rights and its jurisdiction. I think you have 15 minutes, Prof. The Zoom is yours, please.
Well, thank you very much, Professor Blusser, and all the authorities of the Universitas Kristen Indonesia, and the students from our community and all our colleagues around the world. Good night for my Argentinian colleagues. First of all, I would like to thank and send my special greetings to the Universitas Kristen Indonesia, which extended the present invitation to speak for the 27th anniversary of the postgraduate program. It's very remarkable, the achievement either for the Center of Investigation in International Studies and Regional Integration, as well as for the University of Mar del Plata, to develop cooperation, conferences, and programs with our dear friends of Indonesia and all around the world. I would really like to look forward for further programs that enrich our relation altogether. Today, as the professor mentioned, I will talk about the Inter-American Court of Human Rights and its jurisdiction, which I see as an interesting topic to share with you in the framework of the 74th anniversary of the Universal Declaration of Human Rights, which was adopted by the General Assembly of the United Nations on December the 10th of 1948 in Paris. In our continent, the Americas, we could develop a system called the Inter-American System on Human Rights that stands in parallel with the universal model, following the tradition initiated in the American countries in 1881, which was the year of the first Inter-American Conference. First of all, we will talk about the historical background and establishment of the Inter-American Court of Human Rights, one of the most important organs of the system. The court, as it's called, is an autonomous judicial institution under the auspices of the Organization of American States. The court was created by the American Convention on Human Rights in 1969 as one of the two organs overseeing the fulfillment of the commitments made by the state parties. The other is the Inter-American Commission on Human Rights, which was established by the organization in 1951 and received a new statute in 1979. The structural relationship between the court and the commission under the American Convention on Human Rights was substantially modeled on the relationship between the European Court of Human Rights and the European Commission on Human Rights. However, the functions of inter-American commissions are broader than those formerly performed by the European Commission of Human Rights, and the Inter-American Commission also retains its earlier role of human rights monitoring with regard of the OAS member states that have not ratified the convention. The court, which its permanent seat is in San Jose, Costa Rica, consists of 7 judges elected for 6-year terms by the state party of the ACHR, and they might be reelected only once. Candidates may be nationals of any member states. Also, the court is assisted there by a full-time secretariat, which is appointed by the court itself and the staff of the OAS Secretary General in consultation with the Secretary of the Court. Although the official languages of the court include Spanish, Portuguese, French, and English, at present, a significant amount of recent material is available only in Spanish, which is also important to remark because the United States has not signed the convention. It is important also to clarify that the American Convention on Human Rights gives the court both advisory jurisdiction and contentious jurisdiction, like any other international organ. The advisory jurisdiction extends both to the interpretation of the ACHR and to interpretation of other treaties concerning the protection of human rights in the American states. The court has construed the latter category quite broadly. It includes any treaty to which an OAS member is a party and which addresses human rights. Thus, bilateral, regional, and global treaties are covered. For example, the court has held that its advisory jurisdiction embraced a provision of the Vienna Convention on Consular Relations of 1963, which in its opinion confers different human rights. Advisory opinions might be requested by any OAS member state or by organs of the OAS within the respective spheres of competence. An OAS member state may also request an opinion concerning the compatibility of one of its domestic laws, an ACHR, or another human rights treaty. This is very important because it's something that it's model different than the European system. In this regard, states initiating the procedure need not to be parties of the ACHR or have accepted the contentious jurisdiction of the court. Within its procedure, it's important to clarify that the state's withdrawal of request for any advisory opinion does not restrict the court discretion to exercise jurisdiction once vested. This is typically from other jurisdictional organs such as the International Court. In interpretation of the American Declarations of Human Rights and Duties of Man, the court has affirmed its advisory jurisdiction to express its view on the legal effect and meaning of the American Declaration of the Rights and Duties of Man, which is not a treaty in connection with the ACHR and the Charter of the Organization of American States, which are. About its contentious jurisdiction, either a state party to the ACHR or the Commission itself might submit a contentious case to the court. It's important to clarify that, unlike the mandatory competence of the Commission to receive individual petitions, the competence of the court in both interstate cases and cases submitted by the Commission is consensual. For this, it requires either a prior declaration recognizing the competence of the court as binding or a special agreement, like any other jurisdictional organ, for example, the International Court. The contention jurisdiction of the court is considerably narrower than its advisory jurisdiction. As we can see in Article 62, the ACHR itself and not other human rights treaties. Nonetheless, the contentious jurisdictions might be broadened either directly or indirectly. First, Article 77 contemplates the expansion of the list of rights and freedoms protected by the ACHR by means of protocols, for example, the additional protocol to the American Convention of Human Rights in the area of economic, social, and cultural right, known as Protocol of San Salvador, which establishes obligations regarding a variety of economic, social, and cultural rights, but identifies only two of those as subject to the individual petition procedure to the Commission and the contention jurisdiction of the court. Finally, the court often construes rights protected by the ACHR in the light of international human rights treaties and soft law standards. In that connection, the court has sometimes ordered states that have infringed the ACHR obligations to remedy those violations by achieving compliance with other international standards. Concerning the contentious procedure against the court, individual cases can reach the court only after having been processed by the Commission. As a result, the Commission plays a very important role as gatekeeper, especially because only a small fraction of the petitions communicated to the commissions are ever processed to completion. In the early years of the court, the reluctance of the Commission to submit cases severely limited the court activities. In the current period of greater cooperation between the court and the Commission, the choices of the latest still affect the range of issues that the court has opportunity to decide. It is also important to mention that if the Commission concludes that a state has violated the ACHR, it sends a preliminary report on the merits with remedial recommendation. If the state does not comply with the recommendation, then within 3 months of the report, either the Commission or the state might refer the case to the court, assuming the state has accepted the contentious jurisdiction. Within the resolution of a case, the court engages in a fact-finding after receiving evidence through a variety of means, including the live testimony of fact witnesses and experts, submission of affidavits, and documentary evidence. The court has avoided specifying a particular burden of proof for demonstrating the factual basis of an alleged violation. It does not limit itself to the evidence previously submitted to the Commission, and it is not bound by the latest conclusion of facts. Also, the court has cautioned that it does not seek to evaluate the correctness of the decision of national courts, but rather to determine the compliance by a state with their specific human rights obligation. In this point, the court has sometimes found it necessary to reiterate that it does not condone crimes or terrorist attacks while finding a state responsible for violating the rights of individuals who might have perpetrated them. In interpreting the ACHR, the court has emphasized the sui generis character of human rights treaties and the doctrine of effectiveness, clarifying it has pursued an evolutive interpretation of the treaty, drawing on other regional and global human rights instruments and the case law of human rights tribunals or to enrich its meanings. About its reparation authority, the ACHR grants the court a broad one when it finds violations, including not only compensation, but also that the injured party may be ensured the enjoyment of his rights of freedom that was violated, that the consequence of the measure or situation that constitute the breach of such right or freedom be remedied. Given that a high proportion of the court's caseload has involved torture, extrajudicial execution, or forced disappearances, restoration of the status quo ante has not always been possible. After initial hesitations, the court has been both expensive and creative in exercising its remedial authority. Depending on the circumstances, compensation has included both material and immaterial damages paid to the primary victims and close family members, as well as costs and fees. The court's suspicion of military trials reflects the treatment of the military as a separate privileged class and the use of its tribunals to both repress outsiders or to immunize insiders. For example, in the Castillo-Petrucci case, the court found numerous violations of Article 8 of the ACHR in the trial of terrorism suspects by faceless military tribunals, but also state flatly that placing civilians under the jurisdiction of military courts violated the ACHR. In our case, in Las Palmeras case, the court further held that military courts should not be entrusted with jurisdiction to try soldiers for crimes against civilians, but rather should be limited to offenses specific of to the interest of the military in order to provide an independent and impartial tribunal to the victims of or their next of kin. There is also another difficult between three main characteristics of rational themes that have contributed several of the court's most important decisions. One is forced disappearances. In our continent, that was a very difficult topic in past years. The difficult struggle against these kind of cases, as well as the impunity for severe human rights violation, has held the court to condemn other obstacles to punishment of the violators. In this point, it rejected amnesties in broad and seemingly absolute terms in the Barrios Altos case. It also insisted that prescriptions due to passage of time could not bar prosecutions for police brutality leading to the death of a minor in the Bulacio versus Argentinian case. Also, the court has admonished that prior unfair acquittals cannot preclude the reopening of prosecutions against perpetrators through the vehicle of sham double jeopardy. Also, the obligation to investigate and punish acts of torture or forced disappearances is jus cogens, according to the court. And the rule of imprescriptibility of war of crimes and crimes against humanity, it's also a very important leading case in the Almonacid Arellano case against Chile. In conclusion, I would like to say that the court operates under extremely difficult conditions, The region suffers from poverty, social division, recurring political violence, and weak institutional of the rule of law. On the other hand, the court has built up a capacity for determining states' responsibility for human rights violation that they commit or tolerate, and for generating doctrine, expanding the concise language of the ACHR. Some of this doctrine is imported from European or global systems, while other elements are created by the court itself. It's important to mention that the court has not usually searched for an existing regional consensus. Sometimes the court has succeeded because national courts cite its doctrine or because its decision facilitate a political will for reform, for example, after a regime change. While in some other times, the court has contributed to the legitimation or marginalized groups seeking attention and justice. Well, finally, I would like to thank everyone again for the invitation, and I look forward for further questions.
Thank you, Prof Mariano, for excellent presentation. I think, ladies and gentlemen, we already heard about how the history of the inter-American system of human rights. I think there are two substances that's very important that already told or spoken by Prof Mariano. The first one is about the Inter-American Human Rights Court, or IHR, IHRC, and the second one is about the commission itself. So beside the history, Ms. Prof Mariano also mentioned about who is the members of the court, yeah, and also the difference with the European system, and how in the development the role of commission increase, yeah, and play more smooth. I think more smoother decision before all the cases going to the court, and and also he also mentioned about the different treatment between the military criminals with the civilian criminals. I think that's I can give a brief summary about Prof Mariano, and I think we will wait for the participants to make question after this session over. Now we're going to for the third presentation. Yeah, for the third presentation will be spoken by Prof Romina Manizo. Correct me if I'm wrong. Prof Romina Manizo. Prof Romina Manizo, she's an attorney, graduated from the Mar del Plata National University, and also a specialist in Chinese studies. She is a professor of public international law and regional integration. She obtained a scholarship of visiting program for young sinologists to research on Zhejiang University of Finance and Economics in China. And also she's part of the Research Center of International Law and National Integration in the Mar del Plata National University. Her area of expertise is based on cooperative relationship at regional and international level, sustainable development goals, and human rights. She will speak about the challenges for a culture of human rights in the ICT concept, in the ICT context, information communication technology, the fourth generation. So, Prof Mariano, you have 15 minutes. The Zoom is yours, please.
Thanks so much. It's a great honor for me to participate in such an important international event to celebrate the Universal Declaration of Human Rights. Thanks. I request permission to presented my PPT Word document.
Share screen, Panitia, please.
Okay,
Thank you.
thank you. Okay. On this occasion, we will talk about digital rights, understood as an extension of the fundamental rights from the Universal Declaration of Human Rights issued by the United Nations Organization. This implies the promotion of a global model of digital transformation that reinforces the human dimension and provides digital solutions based on respect and protection of human rights. We are going through a period in history of deep changes and social disruption brought about by the fast expansion of digital communication infrastructure and the adoption of digital technology at invaluable levels. For this reason, the protection of human rights in the 21st century will be based on our capacity and international community to articulate regulatory strategies to guarantee, promote, and make effective human rights in the digital context. The constant innovation of information and communication technologies, the wide use of social network, electronic commerce, and telematic activities, both in the public and private sectors and in the personal sphere, demonstrate the evident incursion of the human beings in the digital environment. We must bear in mind that the information society is not only based on the use of the internet, but also includes a set of social, economic, and cultural interrelationships with ICTs through a wide variety of devices, tools, and infrastructures allow the production, dissemination, and processing of information. This also implies new challenges for the possible violation of human rights. The human presence in the virtual space is undeniable, and in this context, there are many transactions and relationships that exist. Hence, the relevance and need to advocate the recognition and guarantees human rights in the virtual world. During the first World Summit on the Informational Society held in Geneva, Switzerland, in 2003, and sponsored by the United Nations through its specialist agency, the International Telecommunication Union, the benefits of technology progress were recognized, and the effects of the rise of the internet and ICTs were also endlessly examined, making it necessary to work on plans to address the digital divide, threats, and risks that the virtual world implies. It is within this framework that the Declaration of Principles was proclaimed. This provides for an information society where there is an equal opportunity, freedom of expression, respect for dignity and privacy, fundamental values that must be recognized and guaranteed also in the virtual environment. In relation to the doctrinal discussion about whether we are facing existing rights or the proclamation of new rights, already in 2012 and later in 2024 and 2016, the Human Rights Council on the United Nations agreed in a resolution that the same rights that people have in non-virtual world is bliss offline world must also be protected in the digital world, online world. This means that rather than the United Nations seeking to define new rights for the digital environment, it had recommended extending existing human rights to the digital context. The same right exists on the internet as outside of it. That is an action proclaimed by the General Assembly, the United Nations, at the Human Rights Council. We talk about digital rights, fourth generation human rights. Today, although each state is developing its own Bill of Digital Rights, either individually or in a regional framework, there are general lines that all of them follow and that we will review. Universal and equal access. People should be able to access the internet regardless of their income, their geographical location, or their disabilities. The UN Human Rights Council recognizes in a report that the right of access is essential to freedom of opinion. Right to identity in the digital environment. The right to one's own identity is enforceable in the digital environment. This identity will be determined by the name and by the other elements that make it up in accordance with the national and international legal system. The identity cannot be controlled, manipulated, or supplanted by third parties against the will of the person. Freedom of expression, information, and communication. These basic human rights are entrenched on the internet when governments block websites or social networks, which is a violation of the right to communication and free association, or censor context, which is contrary to freedom of expression and information. Any measure taken by companies and states to regulate speech must respond to the principles of legality, necessity, and proportionality. Privacy and data protection. Citizens must have control over who store their personal data and be able to delete them anytime. The right to privacy is strengthened on the internet by the theft of credentials, the appropriation of personal data, and their use for financial gain. Right to be forgotten. This is the right to have a person's private information removed from internet searches, database, and directory. It is currently recognized by the EU in the GDPR as a right to delete, and it has already been involved in other countries such as Argentina, South Korea, and India. Intellectual property. Others must be guaranteed recognition of their artistic or literary work and the right to be remunerated for its use, while guaranteeing free access to works that are already in the public domain. Okay. We talk about towards an international agreement. Okay, let's see. The efforts of the international community to create an international agreement, international accord about principles and binding regulations for all states are highlighted. The UN high-level panel of digital cooperation was established in July 2018 and in 2019 presented a final report, The Era of Digital Interdependence. On 11 June 2020, the United Nations Secretary General issued a roadmap for digital cooperation, which addresses how the international community can better harness the opportunities presented by digital technologies. At the same time, he talked about his challenge. Among the recommendations given are ensuring the protection of human rights in the digital era. Human rights apply online just as they do offline. Digital technologies provide new means to exercise human rights, but they are too often also used to violate time. Data protection and privacy issues, digital identity, the use of surveillance technology, online violence and harassment are of a particular concern. Achieving universal connectivity by 2030. And estimated that 3.7 billion people, almost half of the world's population, currently do not have access to the internet. The least developed countries are also the least connected, with only 19% online. By 2030, every person should have safe and affordable access to the internet, including meaning use of digitally enabled service in line with the Sustainable Development Goals. Promoted open source solution for a more equitable world. To unlock a more equitable world, a global effort is needed to encourage and invest the creation of digital public goods, open source software, open data, open artificial intelligence models, and open standards and content. This is also key to achieving the Sustainable Development Goals. Promoting trust and security in the digital environment. The digital technologies that underpin core social function and infrastructure, including supporting access to food, water, housing, energy, healthcare, and transportation, need to be safeguarded. A broad and overarching statement outlining common elements of an understanding of digital trust and security, endorsed by all member states, could help to shape and share vision for digital cooperation based on global values. For final comments, conceiving society without the existence of normative parameters that favor the coefficient of its member and unthinkable. The history of humanity and the contribution of legal science have made it possible to form a human society that, although in a continuous process of evolution, intends to be increasingly organized and impose novel missions in order to foster the development and promotion of fundamental values such as freedom, respect, equality, and dignity of the human being. The right to universal access to the internet, to the protection of personal data, the right to privacy and to be forgotten, as well as the right to digital security, information, and digital education are just some examples of the so-called fundamental rights of fourth generation. Its promotion, protection, and effectiveness must be guaranteed by the international community. Hence, the need for the progressive development of international regulation that's a bearing of states. Today, we face great challenge that violate human rights in the digital environment. Computer crimes, cyberbullying, missing information, among other events that take place in the virtual world are daily news in many media. This impact on citizens implies the need for urgent message by the international community to respect and guarantee human dignity. It is true that the speed with which technology evolves is different from the pace of the dynamic of regulated framework and legislation. For this reason, having up-to-date and precise law is essential in order to recognize and guarantee such digital rights as fundamental rights. Hence, the importance of beginning and continuing with the reflection on this essential issue, moving forward with the recognition and promotion in this respective space action that culminate in the materialization of law in accordance with the reality of the digital age in which we live. Thank you.
Thank you,
so
Prof.
much.
Romina Manzo, for the concise and excellent presentation. I think it's very interesting and complement what the Prof. Fabio already mentioned. Yeah, and you already mentioned about digital right as an extension of the fundamental right. Yeah, and also you give us some details about. I think this is a quite new terminology for us. about how the digital right defined as a universal and equal access, freedom of expression, information communication, and also privacy and data protection right to be forgotten, and also the intellectual property. And I think the key, if I allow me, you said that how we get an effective protection or to safeguard our human rights, yeah, to deal with the great challenge of the violation of the digital rights. So you said that we need an international law. Yeah, we should develop the international law so we can promote trust and security in our chaos digital environment. I think that's a very interesting point from you, Prof. Romina. And I think we already heard about the three speakers, and we will start the question and answer session. Please, if is there any all the participants want to ask directly, because I am not see one or two questions in the chat room. Please, or the participant or everyone in this Zoom, if you want to directly ask question, and if in Indonesia, you can ask in Indonesia. Maybe I can help a little bit to translate in English. And but please okay, one already raised his hand, Mr. Fairly Adi. Okay, Mr. Fairly Adi. With further ado, I think please you can ask your question, and after that, Ms. Yani Ariasi. Please, Mr. Fairly, just write to the speaker which speaker you want to ask. The Zoom is yours.
Terima kasih Pak Producer. Good
Okay.
morning to Mariano, Rumina, Pak Fio. Good morning, Patron. Okay, I'm very interesting about if we are talking about human rights. But so far, what we understand about human rights, I talking about from my viewpoint is, please correct me if I'm wrong. This is my only opinion, and I need your opinion. What is my opinion about human rights is human right is nonsense. You know why? Because human right is only weapon from the European and from the United States to invasion other country with the reason no human right there. So the European and the alliance and United States alliance using the reason of human right. The reason is human right, so they can invasion other country. Let's say,
Mr. Fairly, please,
yes,
to the point. Please, to the point. What your questions?
my question is it correct, my opinion or not? Thank you.
Okay, thank you, Mr. Fairly. So, Mr. Fairly, I think a very straight question. Is it true that human rights is a tool of violation to other country? I think, Mr. Speakers, Mr. Fabio, or Prof. Mariano, Prof. Romina.
I think we all have something to say, but I hope and wish that which is fairly wasn't correct, because we will remain without job if the subject disappears. But what Fairly said, it's something that it's called the cultural dimension, or the cultural critique of human rights. That and it's right in the beginning, because the background of the theory of human rights is entirely European. There's no other participation of other cultures in the construction of the theory. So, but the cultural critique of human rights has an answer, that it's that if human rights there's a need for human rights to be universal, so that cultural critique should be overcome. How? Well, including some other ways of exercising rights. Exercising rights according to other cultures, respecting other cultures. Of course, that the theory of human rights can be used as a weapon, but it shouldn't be what the doctrine says, that human rights must be universal because the human being is the same anywhere. That's the thing that we started saying as regards the value of dignity. Dignity is an absolute value, and it's inherent to every human being. That's a theory we have to work for, to turn human rights really universal. But there's also it's also true that there is a double standard of human rights. The other day, I was in a lecture by a professor of human rights, and he was talking about that double standard with the Ukrainian refugees and some governments. I think he talked about Hungary, and two declarations of the president of Hungary, saying that there won't receive any more immigrants, refugees in 2020, because he was talking about some kinds of refugees that he didn't want. But when the crisis in Ukraine started, he said that his country will welcome any refugee. So there was a double standards according to where the refugees come from, and that double standard exists. So it's a theory that was born European, was born with just one culture. But if we really want to turn it universal, we have to work for it. So I think it's not nonsense, not at all. Thank you.
Okay, thank you, Prof. Fabio. I think it's very clear. Yeah.
Sorry.
You want to add some, Prof. Romina, please?
I recommended an author for this issue, Alan Supiot. He talked about human rights and the necessity of universality, the human rights.
Yep. I think that's very important, the universality of human rights. Please, Prof. Mariano.
Well, thank you, Professor Glasser. And I want to say that partially I agree with what Fairley said. Actually, human rights, as Dr. Farinella spoke, are a category invented by the European countries. But I also think that there is a sort of Trojan horse in this definition about the universality of human rights, because at the deep end, it is a way of intervening in the sovereignty of the countries, in somehow going against what Article 2.7 of the UN Charter says. But in this way, that universality that we're talking about can make also that central countries or global north countries, such as the European ones, as Fabio mentioned, we can see this in the case of Ukraine and Russia, but also in other cases such as what's happening now in Kosovo, or what's happening with the refugees crisis in Europe generally, that also the global north countries are somehow going against the human rights declaration, and especially the one that we are commemorating today. So in this point, I have to say that I agree partially with what Fairley said, but also I want to recommend, such as Romina mentioned, a book of Stephen Krasner. He's an author that wrote the book Sovereignty, Organized Hypocrisy. It talks about somehow how human rights are used to intervene in the sovereign of countries. But I have to say that also I think that human rights have a purpose, and that the only way to make them succeed are by proclaiming them in a universal system, also with rational systems such as the Inter-American one that I mentioned, and also one for Asia, with the culture of Asia, with the religions of Asia, and with the dialogue with the universal system. So that's my opinion, and I hope that I could answer the question.
Oh, okay. Thank you, Prof Mariano. It's always a continuous debate about the universal values with the specific values in all its nation. Prof Avio, it's never end. So I think thank you for your comment about the double standard. Yeah, it still happen. Now for the second participant, I will question Mr. Chandra. Please, the time is yours.
Yes, yes, thank you, sir. Thank you. Good morning, everyone. I'm Chandra from the student is University Christian Indonesian Magister Law. My question is for our sharing from the three the people, the teacher, about the human rights. I'm not agree with the two human right. Is the why I said with the human right it's not running what our expectation because looking at Israel in Palestine, so many people are killing and children also die, and also like Russian and Ukraine conflicts. So United Nation still not looking have the power how to solve the problem. If we have the problem, why United Nation call the two country make the conflict sitting
Mr.
together?
Mr. Chandra,
Yes.
please straight to the question. What's your question?
Okay. The human right is not running as per our expectation. My question is, if we want to start talking about human right, please, we are making ourselves all the people in the world like religious people. Religious people, they're thinking the human right is running like our religion. Like Christians say, we cannot be killing everyone. Muslims say also, we cannot agree with the killing all the people. The human right is what people running in the world is, I think, is not running as per our expectation. The human right is like all the people in the world come with our religious people. This is my opinion.
Okay.
Please our your question. Three people from the you're sharing the human right.
Okay. We got the view. We got the cue. So I think Mr. Chandra comment about the role of the religion should be implemented in the human rights. So he wants to hear your comments about his opinion. So is there any comment about the statement that Mr. Chandra stated? Prof Avio, Prof Mariano, Prof Romina, is there any comment?
I just have a very brief and simple comment, not in order to answer what Mr. Chandra said, but something that I think when I was listening to him. Both questions of first from Farley and now from Chandra make us, I think, trying to express what positive things human rights doctrine had added to our world, because the answer for that challenges questions would be to say no, you are wrong, or you are not right, because there are a lot of positive things that exist now because of human rights. But there's also a negative side that we remark when we answer to Farley, and there are a lot of things to do, still to do, but the critic to the human rights is not a critic to a doctrine. I think it's a critic to human behavior, and not any human. It's a critic to leaders, and instead of a critic to leaders, it's more a critic to the system. So the system of sovereign states. So there's not an entity apart from human beings called human rights. It's not an entity. It's us. So the way we implement human rights, and when I say we, I'm talking about anyone, but the ones who decides have a lot of more responsibility. So it's the leaders, and it's also the system in which those leaders operate. That's the thing that Mr. Kandra provoked.
Okay. I think that's we come to the next question. The next participant, I think, Miss Yani. Miss Yani, please. The Zoom is yours. We still not find the questions about the substance that already speak today. Okay, Miss Yani, please.
I can speak. Okay. Hello, everyone.
Okay,
I would like to ask to Professor Romina Mansur, for the last speech about the security. The fast technology innovation right now is hard to predict. How could the law protect everything with the fastest innovation technology in everything, in biology, in digital, in information, in everything, while people is trying to make some new law, then new technology is invented and need to make law again. And how the security could be safe, like things like that.
Okay. Thank you, Miss Yani. So how the technology can secure our human rights or our digital rights? So that's the simple questions. I think I try to simplify it. I try to simplify the questions. Please.
Thanks.
Okay.
Thanks.
Prof Romina, please.
Thanks for the questions, and I think it's a great opportunity to reforms of commitment to promote and protect universal human rights. In this context, we have very research about the security of human rights. Today, we face great challenge that violate human rights and a digital environment. For this situation, it's important that international community create a law, international law, that obligate all parties to complete and vinculate the creation of digital rights and the human rights and all. Thank you.
All right, thank you, Prof Romina. I think we have 2 questions in chat room. Maybe we can discuss this. First question from Fiskar Wiley Sahalong. He asks about your view. I think that the speaker's view about the LGBT, it's about the gender. You know the terminology of the LGBT, right? Is about the gender issue. Whether like transgender, it's about questions about that. Whether it violates human rights or not. That's the question. This perspective that Mr. Fiskar sees about his opinion that all the religious verses made by the God as a good reason for men in life is said for the religion perspective view. So maybe he want your comment. And the second question is about a case from Denny Pangalila. Denny Pangalila has a question about, I think, his experience when he goes to Amsterdam. He went to Amsterdam. Like he said that he saw the toilet has a unisex toilet, which means no two-sex toilet, but more unisex toilet. And think they had violate others when they want go to the toilet. There is no respecting others. So it's almost the same. It's about the gender issue in the human rights. So please, if there are comment from the speakers, want to comment this?
Well,
I can make a.
Mariano.
Okay, please, Prof Mariano.
Well, I think that this problem, of course, it goes back to what we just recently talked. We have a universal system of human rights, and we also have the internal jurisdiction of countries with their own laws. I think that, first of all, there is a limit when we talk about, for example, international crimes. You know, the Statute of Rome of 1998 and all the 4 crimes that it typifies in these cases. But also, we have to remark that there are some cases, especially when we talk about regional systems of human rights, such as the one that Argentina participates, our country, that has evolved a lot in topics about LGBT communities. And our country, for example, has a lot of progressive laws that allow marriage within the same gender, and all other laws that are somehow advanced or more or different, also that the universal system, and of course than other countries that have their own religions. But I think that in these cases there are some boundaries when we talk, for example, about crimes against humanity. When we talk about genocide, those are the cases that the international community have reached to an agreement of what we talk about internal jurisdiction and responsibility of the individual, and international community system, which is inside the UN Charter. And we don't have to forget that the UN Charter is destined to all the people in the world that suffer the 2 world wars, basically. So that's why we are creating a progressive system, like the Charter says. And I think that somehow making a dialogue between religions, inter-religious dialogue, like the Pope and representatives from Muslim religions and Jewish religions and other religions all around the world have agreed to make a dialogue between these communities. So I think that that's the best way to know which ones are the limits and to know in what topics we can go further to include all the diversities.
Thank you, Mr. Mariano. I think, the global has its own characteristics. Yeah, we are so various, we are so different. So that's why the UN should state some article to get a common agreement. I think in the meeting room, before we're going to Mr. Muhammad Kahmet, we have a question from the meeting room. Please give them time to ask directly. So please, in the meeting room, in Aula, there's some question, please ask question directly.
This is Muhammad Kaka Ahmed.
No, Mr. Ahmed, please wait. Hold on. There's one want to ask in the meeting room. Yeah. After this, you can ask. Sorry about that. They already asked me by chat room first, and after that, it's yours. Please, silakan yang di meeting room.
Yeah, thank you.
Ah,
My name is Dasma Maduma Sinaga. You can call me Duma. I'm a student of University of Christian of Indonesia in Faculty of Law Magister. My question is in a connection with the development of the times and technology, especially in this digital era, what has been provided by human rights institution to protect nation in the economy, especially Indonesia and other countries. Harmonization between law and human rights. Thank you.
thank you. Is the speakers already clear
Alright.
about the questions?
It's a bit low. Excuse me.
Yeah.
What's that again, please?
Yeah, I'm
Sorry.
not hearing well also. Please directly to the question. Please direct, Miss Duma.
Connection of
It's very low. Your speaker, your voice.
is this.
Yeah, okay.
I repeat again my question. In connection with the development of the times and technology, especially in this digital era, what has been provided by human rights institution to protect nation in the economy is especially Indonesia and other countries. Harmonization between a law and human rights.
Okay. I think what's the human rights institution can do something like the role of institution in this new fastest technology, in the fastest technology. I think that's the question. It's not mentioned.
Complete with the example, your activities, your function.
Yeah.
Sure.
Okay. Because it is not clear what institutions should be appointed. So many institutions about that. Maybe about like kind of a concept or theory should be used. Please, Miss.
Yes.
Prof Romina. Yeah. Okay.
Okay, thanks. Yes, I'm not especially about economic, but I think that it's very important to create for the international community a law international that obligate the business and the other parties to obligate the respect of human rights in this context, and it's very, very important to advance in this point and create in accordance with the reality of the digital age. I think it's very important to advance in this point and in the effective rules and punishment that person who committed crimes in this point. It's very, very important to normative about data protection and respect and protect in this area, and an economic of course no this necessary for human rights.
Okay, I think it's a very concise answer. Is there any comment, another additional comment from Mariano or the other? Or we go to the last two participants. Please, Mr. Muhammad Kahmed, Kakak Ahmed. Correct me if I'm wrong. Please, the Zoom is yours.
My name is Muhammad Kaka Hamed. Just from Nigeria. Just to portray to what Professor Favor have said about the somebody who asked the questions about that human right is nonsense. human rights is not nonsense. So by the standard of human rights, you can see prospectively from the definitions that human rights standard that recognize and protect the dignities of human being. And you can see prospectively from what I experienced in 2020 during the crisis of the military killing or harassing people on the roads. And when the humans, peoples rise up and go to the street and protest for their rights, and this rights were justified, and the organization was being sanctioned and dismissed immediately. So that this means that the human right, it is not nonsense. It is adequate and to protect the humans of what they are liable for. Thank you. Talk just to protect what the professor favors have just answered to the questions of somebody who said human rights is nonsense. Thank you very much.
Okay, thank you for the additional. I think to emphasize why the dignity of human is very important in human rights. That's why we need the human rights. Okay, Mr. Nur Supriyanto, please. The Zoom is yours.
Okay, good morning, everyone. My name is Nur Supriyanto Sukamto. I'm a student of Magister Law in University Christian of Indonesia. My question to the speaker, currently we are living in the era of internet technology, where the data and communication are very open, which raise the human rights violations. So the question is, number one is, how we can use this technology to help to protect the human rights across countries? And my second question is there any roadmap from any international body to set up an international law or rules regarding this? Then every country can do the ratification for these rules. I think that's my questions. Thank you.
Thank you, Mr. Nur Supriyanto. Very concise, clear. It's almost midnight in Argentina, in Buenos Aires. Nah.
We are going
Okay.
we are going to enter in the 10th of
yeah.
December.
You're 20 hours late compared to us. Okay, please, Provavio.
There are some projects researching on new technologies and the law, and they identify more than 20 different topics and aspects in which law can regulate the advance of technology, of new technologies of information and communication. But some of the topics have many rules at international level. For example, the protection of data protection, the transference of data between countries. And on another very different topic, the cyberware, there's a lot of rules that were enacted, or principles. For instance, cyberwar. There were the Estonian principles, which were made in 2012 after Estonia, who was the first country in history that was victim of a cyber attack, and all internet collapsed for a month in Estonia, and all the administrative public functions were stopped for a month. In 2012, that was a chaos. Imagine now that many other things are run through internet. So there are different fields in which the law is helping, and some others might be developed. Some of them, which doesn't have normative, doesn't have rules, have some problems because they touch some moral issues. I was reading that there was 2 or 3 more questions in the chat that attach to moral situations, and moral situations cannot be standardized because each culture has its own values.
Yes.
And what positive law does is trying to tolerate that all people tolerate each other when they have different values. But there are some topics in which rules exist.
Thank you, Prof. Aryo. I think that's the quote for today. Yeah, the moral can be standard because everyone has different values. Very, very good. Excellent. I think to close these questions and this session, Dr. Anis want to ask, yeah, you can this is the last question I think for this session. Okay, Dr. Anis, the Zoom is yours. Please concise because actually we already finished the time.
Yeah, thank you. It's not a question, it's a quick comment regarding the value of human rights.
All right.
Since there was a reference, human right is nonsense.
Okay.
We know the UDHR, which was adopted in 1948. Till then, we don't had a codified list of human rights. Now, what is the value of human rights afterwards? If we go through the developments in various countries, like there are large number of countries, they have directly incorporated the provisions of UDHR in their constitutions. That is the greatest value of human rights. Secondly, there are countries where the judiciary has used the provisions of UDHR, ICCPR, ICSR, and other human right instruments for developing various rights in their country. So that means, or that shows that the human rights, the so-called human rights, are acting as a base for developing rights in municipal level, and it is acting as a base for constitution. So that's what my comment. So the human right is very important.
All right.
Thank you.
Thank you. So contrary to the nonsense, this is actually very important. Thank you, Dr. Anis, to emphasize that. Now we end this first session. Again, thank you, Prof. Fabio Farinella. This is the second time I moderate your session. And nice to meet you, Prof. Mariano, Prof. Romina. We hope we can see you in another time, another activity. Now I give it back to MC. And again, thank you for your active participation and for your excellent presentation for the speakers, for my distinguished speakers. Thank you. See you all again. Thank you.
Thank you. Thank you all.
Thank you so much.
Thank you. See you. MC, tugas selesai. Saya serahkan ke MC ya. Thank you.
Back again with me, Catherine Monica, as the Master of Ceremony of today's event. Welcome back to the International Conference, Human Rights and Human Dignity. Let's give a round of applause for our first session. I also remind you to always follow the health protocol to keep your microphone muted during the presentations and switch your phone to the silent mode. Ladies and gentlemen, we are moving to our next speakers that will be moderated by Dr. Manotar Tampu Bolon. First of all, I will read the bayonet. Dr. Manotar Tampu Bolon SHMA MH is a law lecturer in Universitas Kristen Indonesia. He received his doctor from Pelita Harapan University, Jakarta, Indonesia. His educational background and his interest in law and humanities led him to become involved in a variety of organizations. So, Mr. Manotar, the floor is yours.
All right. Our distinguished speakers from Latin America, we expect you to stay with us until the end of this session. So now we start the second session. We have 5 more speakers from Pakistan, from Sri Lanka, from India, from Nigeria, and the last one is from Indonesia. So now we go to the first speaker for the second session. We have a very distinguished speaker here, Muhammad Abdullah. He's a lecturer, a PhD candidate, and also Director of Student Affairs from Iqra University, Islamabad, Pakistan. And his topic is about human rights and democracy in South Asia, theory and practice in Pakistan. Mr. Abdullah, are you there? Hello? Mr. Abdullah? Mr. Abdullah? Hello?
Hello. Yeah, Dr. Manohar. Can you hear me now?
Mr. Abdullah, you have only 15 minutes to deliver your materials before we go to the next presenter. So the Zoom is for yours.
Thank you very much. A very good morning to everybody. Today, my topic of presentation is the human rights and democracy in South Asia. And I'll be having sharing the specific details about the theory and practice in Pakistan. It primarily deals with the struggle for democracy and human rights in Pakistan and how there was an evolution of Pakistan's constitution and the challenges faced by the constitution makers. It will also deal with the difficulties faced by Pakistan and major constitutional issues confronting the country. If we have a look onto the constitutional development in Pakistan, Pakistan became the signatory of UNDHR in 1948, and thereby promising all those rights as the fundamental rights into its constitution. However, as we all know, there is always a difference between theory and practice. More or less same thing happened with Pakistan, and we'll be concluding that by the end of it, along with sharing all those key findings. Those have been found after a thorough survey of the 5 major cities of Pakistan. Fundamental rights are the basic rights of the citizens. Fundamental rights are those rights which are personal to the individual as a citizen of a free and civilized country. According to the Constitution of 1973 of Pakistan, all citizens are equal before the law and are entitled to equal protection of law. To fulfill this objective, Constitution of Pakistan has provided some fundamental rights and freedoms to Pakistanis. The Constitution contains 25 rights in all, which are mentioned into 2 different categories. 15 of them are related to the civil and political rights, whereas the rest of the 10 are social and economic rights. If we quickly go through these promised fundamental rights in the Constitution, there is Article 9, which talks about the security of a person, and it also declares that a person cannot be deprived of his life or liberty except in accordance with the law. Then there is Article 10, which speaks about the safeguards as to arrest and detention, which means every person who is arrested and detained in custody will be produced before a magistrate within a period of 24 hours of such arrest. Article 10 talks about the right to fair trial. A person having criminal charges against him has the right to consult or be defended by a lawyer of his choice. Article 11 abolishes the slavery or the forced and the bonded labor. Slavery is forbidden in all forms of the forced labor are prohibited under Constitution. No person can be forced to work against his will. And likewise, no child below the age of 14 years shall be engaged in any factory or mine or any other hazardous employment. The rights which have been categorized in the Constitution of the Islamic Republic of Pakistan 1973 as fundamental rights are such that no organ of the state, whether it be executive or legislature, can act in their violation. Article 12 about the protection against retrospective punishment. Likewise, Article 13 is there, which is about the protection against double punishment and self-incrimination. Article 14 about the inviolability or dignity of man. The dignity of man and subject to law, the privacy of shall be inviolable. No person shall be subjected to the torture for the purpose of extracting evidence. Article 15 is about the freedom of movement. Every citizen of the state shall have the right to remain in and subject to any reasonable restriction imposed by law in the public interest and enter and move freely throughout Pakistan and to reside and settle in any part. Article 3 is about of assembly. Every citizen shall have the right to assemble peacefully and without arms, subject to any reasonable restriction imposed by law in interest of public order. Article 17 about the freedom of association. Every citizen shall have the right to form associations or unions, subject to any reasonable restrictions imposed by law. Every citizen not being in the service of Pakistan shall have the right to form or be a member of a political party. Every political party shall account for the source of its funds in accordance with the law. Likewise, there is Article 18, which talks about the freedom of trade, business, or profession. Article 19 about the freedom of speech, which has been cursed in many parts of the world in modern time period. Every citizen of Pakistan shall have freedom of speech as well as expression. There shall be freedom of the press, subject to any reasonable restrictions imposed by law in the interest of the glory of Islam or the integrity, security, or defense of Pakistan. If we conclude this all into a nutshell, in order to find the real situation or the gap between theory and practice, there was a survey which was conducted in 5 major cities of Pakistan, 4 provincial headquarters and 1 federal capital of Pakistan. And we have reached to these key findings. I'll be sharing these findings with all of the distinguished participants. We reached to a conclusion that the perceptions of the government and accountability, there is a high perception of impunity in Pakistan, though perceptions of government accountability vary across all these cities. The second major issue is corruption across institutions in Pakistan. That is again a gap or a void between the theory and practice. Pakistanis believe that a significant number of authorities are involved in corrupt practices. Police are viewed as the most corrupt authorities, while judges and magistrates, which is in reality the judicial system of Pakistan, are seen as the least corrupt. Then there is bribery victimization. Petty bribery is pervasive in Pakistan. More than half of the Pakistanis have paid a bribe to receive assistance from the police, and a quarter have paid a bribe to process a government permit. Since 2013, there has been an overall decrease in bribes paid to police officers to process a government permit and to receive medical attention at a public hospital. Fundamental freedoms are banished at times. Pakistanis have moderate views of political and media freedoms in the country and quite positive views of religious freedoms. Since 2016, perceptions of political, media, and religious freedom in the country have improved. Crime victimization. Crime rates in Pakistan vary by type of crime in city. Rates of armed robbery are the highest in major cities, while burglary rates are the highest in another city of Peshawar, which is adjacent to the borders of Afghanistan. On average, there has been a decrease in the rates of all 3 crimes since 2016. Criminal justice. Incompetence of criminal investigators was cited as the most serious problem facing criminal investigative services in Pakistan, while inadequate resources were cited as their most serious problems facing criminal courts. Perceptions of police corruption and respect for suspects' rights have improved in recent years. Access to civil justice A large majority of Pakistanis who were surveyed experienced a legal problem in the last 2 years, with problems relating to community and natural resources, consumer disputes, and public services being the most common of those. Pakistanis have a moderate amount of legal knowledge. Then comes the women in the society and also the women's rights. There are minor differences in men and women's views regarding the rights of women when it comes to divorce and dispute resolution, but the perception gap grows for questions related to inheritance and household dynamics within the Pakistan. Internally displaced people, as we all know, Pakistan has been a country which was the front and the key role player against the war on terror. And there was internally displaced people within the northwestern side of Pakistan. Views on internally displaced people in Pakistan vary by topic and by city. On an average, only half of Pakistanis believe that IDPs are welcome in their community, but more than 2/3 believe that the government is doing enough to help IDPs. Refugees in Pakistan, these refugees are actually those Afghan people who left Afghanistan and started residing into Pakistan from 1989 onwards. And there was another influx which was faced by Pakistan later on at the time of the initially in the Karzai government and later on again in the past years. Views on refugees in Pakistan also vary by topic and by city. Half of respondents believe that the refugees should be guaranteed the same constitutional rights as citizens of Pakistan. When asked about the seriousness of various problems relating to refugees, the largest percentage of respondents said that refugees bringing violence and extremism to Pakistan was a serious problem. Less than half of respondents believe that the refugees and citizens are treated equally by the police. Pakistanis have a high degree of trust in fellow citizens across institutions. Pakistanis have the most trust in the courts and the least trust in the police, though trust in the police has steadily risen over the past years. As a conclusion, what can be concluded in view of the aforementioned facts is that Pakistan's struggle for human rights and democracy is still not over, and there is a long way to go. The majority of the people support democratic values and institutions. However, it is unfortunate to note that the majority of political parties and politicians in this country lack democratic mindset and practices, and this is thereby depicted into general masses and the general public of Pakistan as well. Until there is an institutional shift in a democracy, it will remain a distant dream to see rule of law. That's all from my side. I'll be happy to take any questions by the end of this session. Over to you, Dr. Manohar.
Thank you, Mr. Ahmad. This is very clear, yeah. I will try to translate into Indonesian. Topik Pak Muhammad ini menceritakan tentang perjuangan hak-hak asasi manusia dan dalam konstitusi Pakistan. Dia mengatakan di sana banyak sekali kesulitan yang dihadapi oleh pemerintah Pakistan ketika mereka mendrafting konstitusi ya, karena pengaruh-pengaruh politik. Masalah ini yang paling banyak dihadapi pemerintah Pakistan, termasuk masalah-masalah eksternal dan internal yang mengakibatkan gagalnya demokrasi di Pakistan. Mereka punya hak-hak asasi manusia atau hak-hak yang diakui dalam konstitusi ada 25 katanya di sini. Tetapi hak-hak ini tidak konsisten sama sekali ya. Tidak konsisten. 25 hak dalam konstitusi Pakistan itu baik dia berhubungan dengan hak-hak sipil dan politik dan juga hak-hak ekonomi dan sosial itu tidak berfungsi sama sekali. Persepsi tentang pemerintah, akuntabilitas pemerintah mereka itu banyak sekali impunitas di Pakistan ya. Nah kemudian di sana juga tingkat korupsinya tinggi, yang baik yang dilakukan oleh polisi dan pejabat-pejabat publik, hakim dan jaksa juga di sana merupakan pihak-pihak yang paling sedikit korupsinya. Nah kemudian di sana juga ada terjadi suap menyuap, disebut di sini dari tahun 2013 ya. Selanjutnya tentang hak kebebasan dasar yang dimiliki oleh rakyat Pakistan sekarang itu dalam tahap sedang ya. Termasuk korban-korban kejahatan juga banyak di Pakistan, terutama di kota-kota besar seperti Karachi, Peshawar, juga tingkat kriminalitasnya tinggi yang dialami oleh masyarakat Pakistan. Dan kemudian juga untuk proses hukum yang tidak komplit ya, prosesnya tidak komplit dibilang di sini karena tidak banyak di sana sumber-sumber yang bisa ditiru ya atau dilihat. Kemudian juga akses untuk keadilan terhadap masyarakat di sini disebut sebagian besar masyarakat Pakistan itu memiliki pengalaman yang kesulitan ya, kesulitan untuk termasuk untuk menikmati kekayaan alam ya, kekayaan alam dan layanan-layanan publik. Nah, kemudian perempuan di Pakistan disebut di sini adalah merupakan pihak minoritas yang memiliki hak juga, tapi mereka selalu berhadapan dengan masalah hak-hak terutama warisan. Nah, pengungsi dan atau disebut di sini internal displaced people di Pakistan juga tinggi, termasuk orang-orang refugi di sana ya. Nah, kemudian di sini kepercayaan terhadap masyarakat Pakistan juga disebut terhadap kepercayaan terhadap pengadilan, polisi, disebut di sini sudah agak membaik dari selama beberapa tahun terakhir. Nah, dia juga menyimpulkan di sini bahwa masih terjadi sekarang di Pakistan masih berjuang, mereka pemerintah dan rakyat Pakistan masih berjuang untuk memperjuangkan hak asasi manusia dan demokrasi di negara mereka, dan mayoritas rakyat Pakistan disebut di sini mendukung demokrasi, nilai-nilai demokrasi yang ada di negara mereka ya, tapi selalu berbenturan dengan kepentingan politik ya, sehingga demokrasi yang dicita-citakan itu belum bisa tercapai. Itu kira-kira intinya paper dari Muhammad dari Pakistan ya. So now we go to the second speaker from Sri Lanka, Mr. Ravin Tiran Vivekanantarasa. Mr. Ravin Tiran is a lecturer at the Faculty of Education, the Open University of Sri Lanka in Sri Lanka. His topic for today is about the main pillars of the right of children and the state under challenge, of course, in Sri Lanka. So I give 15 minutes for you, sir, to speak to us. The Zoom is yours. Mr. Ravin Tiran, are you there? Hello? Hello?
Yeah, yes. Good morning, sir. Can you hear me? Hello? Can you hear me, sir? Can you hear me?
Yes, it's clear. Thank you.
Okay. Thank you very much. So, good morning, everyone. Especially, I have to thank everyone here, not one by one. So for this wonderful opportunity. So first of all, especially I have to thank my respected colleagues, myself, Dr. Manotera, for this kind invitation to take part in this conference. With that, I thank everyone and all the participants, all the students here, and all the eminent speakers for giving me this opportunity from Sri Lanka. So thank you very much once again. Let me to share my presentation. Okay, give me 1 minute. Okay. Can you see my presentation, sir?
No, yep.
Yeah, okay, thank you. Is it clear, sir? No? Okay. Okay, thank you very much. So that topic that I'm going to discuss on this conference, especially on the rights of human or any related the things that related with the rights of people around the world. The main pillars of the rights of children. Here I have come to the point of the children at the 21st century, how they are facing the challenges and what are the rights that normally we are practicing from from the ancient time, or maybe so within the time, especially that under the challenges that now we are facing around the world in different forms. The challenges are happening. So the state of under challenges. So what are the main pillars, especially that comes under the rights of the children and the challenges? How the pillars and the rights of children are facing the various challenges in this 21st century, maybe the present time around the world. So I'm, the faculty of education, the Open University of Sri Lanka. So online this the presentation, the outlines. So I will talk about this the concept child rights and the overview of the child rights, and also the 4 main pillars of the child rights. So after that, the state of the pillars of the child rights under the crisis. Finally, I will conclude my presentation. So with the steps, what are the steps taken to face the challenges? So considering the time, I have to go a little fast. So when you have the question, you can ask me any question regarding the rights of children and how the children are facing the challenges and maybe the abuses at the present time. Meaning of child rights, when we meaning of rights, when we think about the rights are legal and social or ethical principles of freedom or entitlement, and rights are the fundamental normative rules about what is allowed of people or owed to people according to some legal system, social convention, or ethical theory. So furthermore, the rights of essential importance in such discipline as law and ethics, especially theories of justice and deontologies. This is a small definition for the concept of rights. So rights are various forms. There are different types of rights. We can categorize the kinds of types of rights. So I have listed a few types here: natural rights, moral rights, contractual rights, and legal rights, and human rights. So here we are going to focus on the human rights. Under the human rights, I will come to the point, the rights of children. So rights which are believed to belong to every person, and protection of individual rights such as freedom of speech, press, assembly, and religions. So this is what we call the human rights, which is equal to everyone. So in the world, we are the every person, we are having rights, and we are doing everything with the certain rights that we are practicing, that which are already determined through some theories or rules and the legal system. So in human rights, child rights are type which explain about the rights of children. So if I come to the point, the child rights are the human rights of children with particular attention to the rights of special protection here afforded to children. For example, I can take this example: rights to protection, or you can say rights to participation, or any types of forms of children. So when I talk about an overview of child rights, the child rights, when human rights started in the world, especially they focused on children. They talk about they talk more about children and the rights of children, because they are more vulnerable, and they are used for any certain abuses or certain activities. They are the people can use them for any form of punishment or any difficult activity that may cause some certain problems to them. So one of the earliest recognition of children's rights in 1641, that 17th century, parents were told not to use unnatural severity against their children. Furthermore, children were given free liberty to comply to the authorities of redress. In response to the growing concern in most countries of Europe and North America for the protection of children following the First World War, the newly formed League of Nations established a Committee on Child Welfare in 1990. That's the first step when we talk about the history of child rights or amendments or legal system on child rights. So after that they started develop new amendments or legal system or rules and regulations to safeguard children. Especially, the World War made so many changes, made good instinct to safeguard children in the world after the nuclear attack, the bomb attack in Hiroshima and Nagasaki in Japan. That was the main part of the safeguarding the rights of children. So in 1923, the Save the Children International Union adopted a five-point declaration to safeguard the rights of the children. After that, in the year 1924, League of Nations adopted the Declaration of the Rights of Child, which came to be known as the Declaration of Geneva. So the first concept from Geneva was started in 1924. After that, they further developed, added some points to develop the rights of the children. So in 1945, the United Nations organization replaced the League of Nations. And in 1946, the Economic and Social Council of the United Nations recommended the Geneva Declaration be reaffirmed as a sign of commitment to the cause of children. From the 1924, then 1946, they reaffirmed some with certain points. So furthermore, in 1944, the United Nations General Assembly also adopted further recommendations and so further points to safeguard the rights of the children. Furthermore, you know that in 1959, November 20th, the Declaration of the Rights of Child was adopted by the United Nations General Assembly. So the Declaration of Geneva is major point of major part of the child rights. They adopted, they declared, they brought many things to safeguard the children around the world. From the 1924, after that the 1946. So still the things they adopted, they introduced, are practicing around the world through some certain international organizations, committees, and some countries, even especially some countries are still practicing, not some countries, all the countries around the world. So that's the main part of, that's the main point, the UN, the Declaration of Geneva. So in the Declaration of Geneva, many things were adopted and declared to everyone or all the countries to include in their the human rights system to safeguard the rights of the children. And still many countries are practicing. Though many countries are still practicing, there are many challenges. Students, maybe in the name of different, in the name of safeguarding the children are being practiced and being abused in certain forms. There are incidents, there are evidences. We are just knowing everything. So if I move to the next step, when I talk about this rights of the children, the UN Declaration of the Rights of the Child The UN Declaration also on the major point. The UN Declaration contains certain points to safeguard the rights of the children, non-discrimination, special protection, opportunities for the children, and the right to name and nationality, and some moral adapted things. So these are the main points of the UN Declaration. So if I move to my next slide, further, the UN Declaration explained some further ideas, entitlement to education, how we can offer the education to the children, and how we can make them to be well educated among the society. And also the child should be among the first to receive the protection and relief in all circumstances. So these are the special circumstances which were declared by the UN Declaration. So furthermore, I can tell there are many things to explain under the concept UN Declaration, the protection, participation, and everything were clearly described and put forwarded to everyone in the country under the UN Declarations. So if I move to my next slide, another main part of the concept, the child rights, the Convention on the Child Rights, in safeguarding the rights. It was in in 1989, the world leaders decided that children needed a special convention just for them, because people under 18 years old often need special care and protection that adults do not. So they thought that they need special care and protection. That's why they started to make a special convention that on the rights of children. That was the Convention on the Rights of Children. So in 1989, different countries adopted the concept, and they signed in the document in various years. For example, in Sri Lanka, we adopted the concept, the rights of children, the convention adopted things in 1991. After 2 years from the conference started, after 2 years back. So that's the main part of the when we talk about the overview of the rights of children. So furthermore, if I move to my next slide, the main point in the conference on the rights of children, they adopted 54 articles regarding the rights of children. Among the 54 articles, the articles they group the things, the rights, special rights to the children into 4 broad categories, which are called main pillars that we have to consider when we talk about the rights of children. So which are types of child rights, we can call them as types of child rights, or the main pillars or the clusters of child rights. The first one is right to survival, right to development, right to protection, and the right to participation. If I see one by one, what is right, protection rights, it includes
excuse me.
Yeah, yes, sir.
Hello, excuse me.
Yes, can you hear me, sir?
You have 3 minutes time, please.
Okay,
so
right,
you
okay.
go to the conclusion. Thank you
Right,
very
okay.
much. Yeah.
Okay, so these are the protection rights, and there are many things to explain the one by one. So my another point is the challenges and what are the challenges the children are facing now. So the challenges are the COVID-19 pandemic, Ukraine and Russian war, the economic crisis. So we can look at the challenges, how the children are facing the challenges under these three circumstances or the situations. The children's under challenges, they are facing different violences or the difficulties. When we talk about education, violence at home, child labor, sexual exploitation, including online, children deprived of liberty, these are the challenges. And the economic crisis and the Ukraine-Russian war. So these are the main points. So though there are challenges, including Ukraine war and COVID-19 and economic crisis, there are steps taken by the different countries. And also main point, the corporal punishment. The corporal punishment is one of the major block point when we talk about the rights of children. This really affect to safeguard the rights of the children. So steps to face the challenges, the different countries are taking different steps to safeguard the children, though they are facing challenges under COVID, maybe economic crisis or the different wars around the world. So different amendments, different rules and regulations, different declarations around the world. So those are the main points. So that's my point from this presentation, the main pillars of the rights of children and the challenges and the different crises, economic crisis and COVID-19 and the Ukraine Russian war and some types of different wars and conflicts. So thank you very much for giving me this opportunity. Thank you. Thank you. Thank you, sir.
Thank you very much, Mr. Rafian. This is very interesting, especially because your topic is related to children rights. I will translate into Indonesia a little bit. Ini papernya Mr. Rafian ini tentang hak-hak anak pada umumnya. Dan dia juga meneliti bagaimana kondisi hak-hak anak setelah COVID-19. Jutaan anak-anak itu kehilangan hak ya. Hak sekolah apalagi, dan yang lebih parah lagi sesuai dengan risetnya beliau itu terjadi di Bangladesh, India, Myanmar, dan anak itu tidak ada harapan untuk dapat sekolah karena memang tidak punya akses internet ya. Dan juga sangat banyak anak-anak yang jadi korban akibat invasi Rusia ke Ukraine ya. Itu juga terjadi hampir di sini menurut data beliau tinggi angka anak-anak yang kehilangan haknya akibat invasi tersebut, disebut di sini hampir 2,5 juta atau 60% anak dari Ukraina itu terusir dari rumah mereka karena invasi atau keadaan perang, dan juga karena krisis ekonomi. Dia menyebutkan di sini jutaan, hampir 5,7 juta anak-anak itu atau 2,5 juta anak-anak itu tidak mendapatkan bantuan yang manusiawi ya. Itu kira-kira risetnya Mr. Rafin dari the Open University of Sri Lanka. So now we go to the third speakers from the third speaker of this session is Dr. Anis V. Pillai. He's from Cochin Law School in India. He got to doctoral degree, assistant professor. I think Mr. Anis is the second time to join us. He also joined us last year in the same conference. Mr. Anis' topic today is about the right to dignity, an international and Indian perspective. So he discussed about what is the dignity, what's the right to dignity, international perspective, and also he combined with Indian perspective. So now, Dr. Anis, you have 15 minutes. We are very strict on time, so you will finish in 15 minutes. Thank you.
Thank you. Am I audible?
Yes.
Yeah. Thank you.
Go.
Thank you. Thank you. From India, on this occasion of International Human Rights Day, I'm very happy to interact with you about a small topic, right to dignity. It's international and Indian perspective. Well, right from the beginning, the different speakers were talking about right to dignity and its human rights perspective. So I'm not concentrating much on right to dignity. but I will just highlight the Indian perspective on this regard. Well, what is dignity? I'll just, for the sake of introduction, I'll just explain to you. Dignity is the core value or foundation for the establishment of human values. Or in other words, without dignity, a person cannot live as a human being. So I would say dignity is certain values, certain instances or circumstances which are necessary for leading a human life. So in the absence of dignity, an individual cannot lead a human existence. That means in the absence of dignity, the existence of human being will be equal to animal existence. So that is the importance of dignity. Now this dignity is being recognized worldwide. Almost all the constitution of the world recognizes dignity. At the same time, you can find express references at international human rights jurisprudence. Different international human rights instruments talks about dignity. Well, when I say dignity, I would say this dignity, the concept of dignity of individual, serves three important roles in any legal system. First of all, the concept of dignity acts as a basis for interpreting or for establishing constitutional rights. You can see there are several constitutions in the world. They have directly incorporated several human rights provisions on the justification that these human rights are necessary for ensuring a dignified life of a human being. Moreover, other than constitutional provisions, there are several countries where there may be an absence of a written constitution. They have also used the concept of dignity for the purpose of establishing statutory rights on the justification that these statutory rights are essential for ensuring.
Excuse me, Dr. Anis.
Please.
Yeah, could you move your slide, please? Your slide is not moving. Yep.
Okay,
that's
now.
Okay. Yep. Okay.
Yeah. Fine. So what I was saying is dignity, the concept of dignity serves three important roles in any country. One is it becomes basis for constitutional rights. Likewise, where there is no written constitution, it is serving as a base for creating statutory rights. Now, second important role of the concept of dignity is it serves as an interpretative principle for determining the scope of constitutional and statutory rights. So there are several countries wherein the judiciary using the concept of dignity for the purpose of expanding the scope of existing constitutional and statutory provisions. I will tell you how this role is being performed in India very specifically. Then the third role which the concept of dignity performs, that is, it determines the proportionality of a statute limiting a constitutional right or statutory right. That means the concept of dignity is acting as a negative or restriction to the state so that the state cannot unnecessarily interfere with individuals or people's right. So these are the functions performed or roles performed by dignity in any country. how this term dignity is being used in international human rights instruments. The Magna Carta of Human Right, that is UDHR, in its preamble itself, very well uses the term dignity. It emphasizes that whereas recognition of the inherent dignity and of the equal and inalienable rights of all members. So the very beginning of UDHR emphasizes the need for recognizing inherent dignity of individuals. Subsequent to that, Article 1 of UDHR very expressly mentions all human beings are born free and equal in dignity and rights. That is the importance given to dignity by UDHR. Then subsequent to that, you can see ICCPR, International Covenant on Civil and Political Rights, 1966. This also incorporate the idea of dignity and attaches importance to it. Now, when it comes to India, yeah, when it comes to India, the idea of dignity is being used very expressly in our Protection of Human Rights Act 1993. If you see the definition of human rights, which is provided in Section 2D of the Human Rights Act, you can see that definition takes care of all rights which are essential for the purpose of protecting a dignified life of a human being. So that way, the concept of dignity is being very well utilized or used by Indian legislatures, and thereby they incorporated the term dignity in Protection of Human Rights Act 1993. And before that, even much before this 1993 Human Rights Act, Indian judiciary has utilized the term dignity for the purpose of expanding the scope of the various fundamental rights which were mentioned in Part 3 of Indian Constitution. One of the very significant case wherein the Honorable Supreme Court of India, that is M. Nagaraj versus Union of India, wherein the Supreme Court has very categorically mentioned it is the duty of the state not only to protect the human dignity, but to facilitate it by taking positive steps in that direction. So the judiciary has clearly mentioned that it is the duty of the state. What is the duty? Not only to protect, but they have to facilitate. How they have to facilitate? They have to facilitate by taking further positive measures. So that means the legislatures has to enact legislations for the purpose of protecting different aspects of dignity. Now, how this particular thing is incorporated in our Indian Constitution? If you see Indian Constitution, you cannot find the term dignity expressly used. But the various provisions of Indian Constitution covers the idea of dignity of human beings. Like Article 14 and 15, which talks about right to equality in public employment, Article 16, abolition of untouchability, Article 17, abolition of titles, Article 18, fundamental freedoms, Article 19, rights of the accused and detainees, Articles 20 and 22, right to life and personal liberty, Article 21, right to education, right against exploitation. All these are rights mentioned in Indian Constitution, and all these rights are impliedly protects the aspect of dignity. And when I am saying it impliedly protecting aspect of dignity, it is expressly declared by judiciary. That is why I am having the argument all these rights indirectly protecting dignity. Now, I'll show you certain cases wherein Indian judiciary has highlighted dignity is very important and the various facets of dignity has also to be protected to ensure a human life. First of all, in the case of Francis Corali versus Mullin, Francis Corali Mullin versus the administrator, the Indian judiciary said every person has a right to live with human dignity. So that's a very fantastic exposition regarding human dignity. Everyone has a right to live with human dignity. Subsequently, in another case, right to reputation, that was declared as a facet of human dignity. Then in another case, right to livelihood is declared as a facet of human dignity. Then right to live in unpolluted environment, that is also declared as a part of right to dignity. Then right to education, that is also declared as a facet of human dignity. Rights of prisoners, large number of rights were declared in connection with the prisoners, like right against custodial torture, right against barfetters, right against solitary confinement, right against public hanging, etc., which are necessary for protecting the human dignity of prisoners. Then you can see right against sexual harassment at workplace. This has been declared as a part of right to dignity of a working female. Then right to shelter, something very important facet of right to dignity. Right to consensual sex. If you are an adult person, you have a right to consensual sex. That is also declared as a part of right to dignity. Then right to privacy. Without right to privacy, none can enjoy or none can live a dignified life. That was also highlighted by the Indian judiciary. Then right to choose life partner. That is also one of the essential facet of dignity. Then right to compensation. Whenever a person suffers a harm or injury at the hand of state, it is the duty of the state to compensate. Otherwise, they will suffer an injury to their dignified life. So the court has stated everyone is entitled to get compensation. Then right to social security. There are large number of occasions state has to protect people in the name of social security so that those persons can lead a dignified life. Then right to minimum wage, right to health, right to medical treatment, right to modesty and self-respect for women, right to reproductive choices of women, right against custodial violence, right against barfetters, right against handcuffing, right to free legal aid, right to speedy trial, right against solitary confinement, right against delayed execution, right against public hanging, right against rape. In fact, Indian judiciary has declared right against rape and evil right, and that will be an injury to a dignified life of a woman. And recently, the judiciary has stated there is a right to access to internet. Access to internet is also considered as a component or facet of right to a dignified life. Then right to sleep, very important right, that is also declared as a facet of dignified life. Then capital punishment, right against capital punishment, right to die. Interestingly, the Honorable Supreme Court has stated there is no right to die in India. Though you have a right to life, you don't have a right to die in India. Because if you have a right to die, that will go against a dignified life. Then euthanasia, to an extent, euthanasia is also allowed in India. Why? Because if you can't go for a dignified death, then sometimes euthanasia, that too passive euthanasia, will be allowed. Now, the very recent development in India is even for animals and birds, dignity is being given. As of now, in most of the countries, we are talking about human rights, that is, rights of the human. But in India, the judiciary went a step ahead and thereby they
Excuse
started
me.
conferring. Yeah, I'll finish in 2 minutes.
Sorry for disturbing you. You have 2 minutes to go, sir.
Yeah, I'll finish. I'll finish. It's
Okay,
ending.
thanks.
So the Indian judiciary went ahead and said, even an animal, even a bird is also entitled to have a dignified life. And the most latest or recent development is even rivers and water bodies, they had given legal personality. And now rivers were also treated as a person, and even rivers can also claim dignity. So that way, the Indian judiciary has expanded the scope of right to dignity. So that's it from my side. Thank you for giving me this wonderful opportunity to speak about few words in this International Day of Human Rights. And this year's theme is freedom, dignity, and justice to all. So I'm very happy to speak few words about dignity and the way in which the concept of dignity is used by Indian judiciary for expanding further the various rights. Thank you. Thank you very much.
Thank
And I'm
you.
happy to answer any
Thank you, Dr.
clarification.
Anis. Ini papernya Dr. Anis menceritakan bahwasanya human dignity itu sebenarnya dignity ya seperti kemanusiaan gitu yang ada di dalam diri manusia. Jadi tanpa dignity itu manusia itu bukanlah seorang manusia, disebutkan begitu. Nah, di konstitusi India itu banyak sekali mencantumkan tentang human right dan human dignity. Beliau juga membuat beberapa kasus di sini ya. Ada beberapa kasus yang terjadi di India, mulai dari halaman di halaman 7 itu dignity di konstitusi India ada beberapa. Nah, kemudian di judicial interpretation-nya ada di halaman berikutnya ya. Jadi pada intinya papernya Dr. Anis Fevillai adalah tentang hak asasi manusia atau manusia itu sendiri tidak bisa dipisahkan dari dignity karena manusia itu bukanlah manusia tanpa dignity ya. So thank you very much Dr. Anis. Don't leave the Zoom because we have Q&A session after 2 more speakers. So now we go to the 4th speaker from Nigeria. Muhammad Kaka Ahmad, PhD candidate. His paper is about current challenge to the International Guard of Human Rights and Dignity. Mr. Ahmad, you have 15 minutes to deliver your materials. We have very strict time, sir. So we only give you 15 minutes. So you can start now. Thank you very much.
Thank you. Good morning to everyone. My name is Mohamed Kaka Ahmed. I'm to present to you the current challenges to the International Guide of Human Rights and Dignity. Dear Assistant Professor Dr. Mukhtar Tambula, Distinguished Congress member, ladies and gentlemen, I am very pleased and honored to take part in the series of events for this international conference. 27th International Conference of the Postgraduate Programs UK High International Human Rights Dignity UK High, the moderator, organizer by the UK High Human Rights Center, and the Assistant Professor Dr. Mukhtar Tambu, SI lecturer at the Magistracy of Law Study Programs of the University Christian Indonesia, and the former moderator, Dr. Pluja, University Christian Indonesia. Permit me to present to you the Provost Kwara State College of Education Technical Lafiagi Nigerian in person of Dr. Muhammad Dede Ibrahim has asked me to convey his greetings and the best wishes for the successful series of these sections. And I wish to thank all of you, and in particular, Professor Assistant Dr. Mukhtar Tambu, the chairs of these occasions, for inviting me as your speaker. And he is my former senior colleague as a University Technology Malaysia. I met him at the international conference in Turkey some weeks ago, and they remain my best friends and senior colleagues. And the lecture series on the national monitoring safeguard representing a careful approach to human rights minority, including the indigenous populations and those who identify as the ethical, cultural, linguistic, religions or racial minorities, and those who are more frequent subjected to discriminations, exclusion, stigmatizations, and acts of hatred. The means organizer that the plight and the support the fight of the justice and the independent expert on the minority issues. On the minority issues and the expert of the minority issues, especially those that are given the freedoms of participating in the dignity, religions, and the social of situations of human rights and the fundamental freedoms of indigenous people. And the focus of this topic is to present a current challenges of the international guide of human rights. Due to the time's constraints, we will not be able to address all of them, but we discuss only some of those that the OHR has identified as its priority. Distinguished participants, the difficult fixing during the right moving targets that demand the highest levels of alertness and the flexibility, universal human rights. NORMA serves as a key, cornerstones and a consistent fundamental upon which our answer context. In doing so, the universities deliberately interdependent and non-selectively principles serves as the cornerstones of the UN systems of human rights. And in light of it, the increased populations movement brought only to this worldwide economics complicate matters and they put the human rights of the migrants, refugees, and other groups at risk. And the greatest vulnerabilities of these people were brought to the light during the Dubai reviews of the conference in the regions and the world during the special Human Rights Council meetings on the food and the financial crisis, which took place in 2020 during the NSACs in Nigeria. And the millions of the people who risk their lives and the security to cross international border across the disease, searching for better lives, and who lives outside of their countries of the origin, and the irregular migrants without sovereign safeguard for the human right, and particularly dramatic examples of these challenges to the human rights. And the examples of this, why moving across the border can be a good and uplifting experience for some people and the family for far too many others during the forces of the sustained prejudice, exploitations, and abuse. And the migrants frequently lack the familiarity with the nation's language law and the custom because of the fact that they're outside in the culture, and the consequently less ability than to order to understand the defense and the rights. Abnormally, they could experience the prejudice and the unfair treatment at work, and the other aspect of their everyday life activities, such as the guiding access to the public service. And in the event of the human rights organizations and the agencies are increasingly criticizing states for failure to adequately safeguarding the migrant of the useful behaviors, and the practice of the mandatory detentions of the criminalizing to the document, and the migrants are victims of the trafficking mistreatment of the border, and insufficient protections, and the documented children, and the lack of the access to schools for migrant children among the recurring issues they are brought up. And the problems that are fixing is boosting up the effort to promote a human rights approach to migrants in light of the scopes of the grievance, the graffitis of a migrant related to human rights concern. And however, issues related to the human rights are all too frequent, if not in the discussions and the policies of migrants. For instance, efforts to reduce the regular migrants sometimes concentrate only on the tightening borders and the immigration regulations rather than tackling the underlying causes of the problems. In addition to being mostly useful, such action bring them a host of the problems relating to the human rights. And in order to bring this topic to the closing, let me emphasize on the fact that when correctly handled, migrations enhance the society by promoting and also the appreciations of diversities and the respect across the people, cultures, and the community, while all boosting the economy, human development in the both homes and the host country. For migrants and their familiar migrants is crucial tool for enhancing living conditions and achieving human rights. It is evidence that these advantages do not materialize automatically, though the implementations of a supportive right based on the fact that the policy measures is a crucial prerequisite. And distinguished ladies and gentlemen, another significant concern of the present is effort of the food crisis in the country across the diaspora in the human rights. And the problems facing this, which has inflicted millions of individuals, especially the social scattered residents in both industrialized and the developing nations, such as a woman, small-scale farmers, and the indigenous people, is not just visible in the increasing global food cost. And the long-term disregard of the investment is agriculture, particularly in the small-scale farming, which one of main causes of the crisis in the migrants. Over the times, institutional barrier to small-scale farmer access to the resources, lifeline, and other productive resources.
Excuse me, Mr. Muhammad.
Yes, sir?
You have only 3 minutes to go, so go straight to your.
Okay, the global challenge of human rights is a financial problem cannot be addressed solely by private enterprises and the evidence of the land grab. And a new versions of how to implement the articles in the UDH and the right of the every woman amount to an international and the social environment in which they can access and enjoy their right. It requires a light of the food. Ladies and gentlemen, to address this issue cooperatively and cogently, a global solidarity strategies have to be implemented in this regard. And the fundamental missions of all these organizations is to protect the human right, which is even more crucial in the light of the current economic crisis. Millions of women are anticipated to be appropriately affected by the present global economic crisis because they are already made up a majority of the poor before the crisis begin. And all of us need to understand this concept of rights defender. Doctor who provide dignified access to care regardless of the patient identifier or social and other means which we need to understand: actives, disturb, provoke, illustrations, and enchant. And the economy who seek a more just distributions of the wealth. In conclusion, we concluded that the commissions politely emphasized that the woman must actively participate in the human rights, community development, and the security are to be fully realized. We must elevate woman pain, but more importantly, we must address the injustice that limits dignities and suppress their potentials. And to also put into the light of this, the governments and the organization and the civil society cannot operate alone. Our unity attention must be on ensuring the stronger protections for the victims of human rights crimes whenever they occur nationwide. Thank you and God bless.
Thank you, Mr. Muhammad. I think your presentation is very, very special, yeah, because you actually discuss about the failure of some of international guardian for human rights, which is leads to violation of human rights, women rights, migrant worker rights as well. Thank you for this paper. Now we have the last presenter from Master of Law Program, Universitas Kristen Indonesia, Dr. Nelson Simanjuntak, SHMC. Dr. Nelson is a senior lecturer at Master of Law Program. He graduated from Universitas Diponegoro for his doctoral, and Sarjana Hukum from University of Indonesia, Master of Science from University of Indonesia as well. He spent years as a public service in Jakarta in the Department of MOHA. Mr. Nelson also joined Universitas Kristen Indonesia nearly 20 years. Pak Nelson will discuss about the darkest case of murder in police environment in 2022, conflict of interest that becomes a field covering human rights. This is very specific case because he will discuss Verdi Sambo case where the victim is Brigadier Joshua Huta Barat. The time is yours. You have 15 minutes, Pak.
Okay. Thank you, my hula hula. Franklin speaking. Hello, in studio Christiani Indonesia University, our student, and also my colleagues and professor in all over the world. And then you are the listener in Indonesia and all over the world. Assalamualaikum warahmatullahi wabarakatuh. Praise the Lord. Only a few good men. Tom Sawyer said. Not only Tom Sawyer, yeah? Tom Crusoe. And then not only black and white to be the said human right activity today. We are now this day, we celebrate our human right birthday for the 72. And now Christiani Indonesia University, same the age is about 74. So that we are celebrate. I'm not sure in United Nations, the Organization of Human Rights in New York, have a cake there. We have a cake in our table until now. So that the last speaker this noon, this day, we'd like to take a good topic in my research. It's about the title, The Darkest, not only the darkness case of murder in police environment in the century 2022. I would like to take study case in conflict of interest that becomes a veil covering human rights. This is a real story. This is a true story. Until now, in Indonesia case, we had law, we had regulation about it, but one more, we had no, because we are living not only in Indonesia, we have one word, so that in our blood, in our frame, justice must be in our body. So that in this time, how about to celebrate this, our campus to do this, so that to the end of this world, there is no human rights against by the law. Okay, move. Let's introduce. Move. How about Indonesia highly respect of human rights? Indonesia until now, if I'm not wrong, the number 10 for the head democracy in this world. So that Indonesia also in his constitution in 1945 we had in Dutch said Rechtsstaat, or Indonesia had laws beyond the law until now. This is the Republic of Indonesia. So that when I show you, this is two colors, not only black and white, Michael Jackson, but this is red and white. It means red is brave, white is holy like a virgin. So if we had Declaration of Human Rights, we also have law 1999 about human rights. There are chapter 70 about human rights. So everybody must be protected by the law in Indonesia. And for the 3 years before, we killed not only by human rights against, but we killed by the COVIDs. But nowadays, let I inform you, there is one topic, good topic, a real story I said now. How about a murderer? This is a simple case, but it must be like a puzzle. Too many mercy, too many traffic lights, too many both and faith, how to make it clear for these cases. So, let we say, what is human right? Human right, John Locke said, move. According to John Locke, he said in 1748, human rights themselves are rights that are innate from birth, are naturally attached to every human being and cannot be contested or are abused in nature. In this case, what is inherent in humans from birth, namely life, is usurped by others. Before we know, John Locke always said in his book that who in this world, in his blood, in this justice, human right must be kept in our body, so that in this world, democracy system and the others must be have the human right being for each other. And now, in our introduction, let me say, even that are very concerning, move. Let's see the pages. Even that are very concerning in the field of crime and humanity. In Indonesia began with the death of, let I say, there are 3 typical in police rank, one high level, the second middle level, and then this the low level. We said Bayangkara. I would like not to say the name, but initial like J is named Brigadier. Let me say it like belongs beyond the surgeon in this world. Yeah. Very simple, very the first rank in police. He died. He killed by his boss. They said that he killed by the shot by shot against the fire by the gun, but it's not clear. And then the second time in this research. And then until now, nowadays in our court in Indonesia, named South Jakarta, and the capital city is the puzzle cases. Very, very difficult to open it because they kills by the college in their teams, in their group, in their police situation. So that how to involve almost all personnel from the high, middle, and also from the low level. Who will be the victim? And then after who will be the victim, will be the involved. After that, who will be dependent of this? Until now, the court said the judge, the prosecutor still make the court for the 7 months. It's not clear. Very, very, like I said, traffic jam. So we can say, you can see, this start from the 1st July 2022, the first time of Brigadier J killed by his boss and the team. They said, not me, not you. And who will be? Who will be the victim? Who will be the one to be defendant? The problem is, can it in our law, the victim will be the defendant? The victim was died. He is living now in heaven, in sight of his God. You know, it's about approximately 1.7 police accused currently under investigation until now. Too many police. In Indonesia, regulation, 400,000 policies. They have doing a professional, they have got salary, they've got the pension, and they've got everything. And that they had his duty, a famous, honorable police in Indonesia. They are law enforcement, and then they do to protect everybody in our country or our state. Our state belongs to 38 province and 600 major and region. So that too large Indonesia, but only this case until today, very, very difficult to make the the solution, because all the staff, high level, may be involved in these cases. So what will we do? How will to involve this and to make the finish this problem? These cases, it means every cases in this world not be finished. It must be happy ending or bad ending. Nowadays, still average. I don't say it's okay until now finished, but we know it will be to be question mark, because our president nowadays four times to say make it clear, and one at here coordinator, minister of law, human rights and political, every time to say make sure for this case. And then the official chief, the commandant of the police in Indonesia, also try to do to finish this. But until now, too many what we call, not only too many a victim, not only too many dependent. We also said 12 from us, the too many suspect, too many indicated, and then too many accused for these cases. So in this big boss, 2 stars. He is a chief of the division, professional, and then commander of the police in this country. 2 star, so that all involved, his wife, and then the servant, and then the staff, too many. And now witness from the victim 12, and then witness from the suspect, from the defendant, it's more 30. Nowadays, let we check again how to solve this. In our literature, how to solve related to the murder. We know in human right, Magna Carta, Bill of Rights, habeas corpus in over the world. I'm very interesting from Magna Carta. This is the first time to do human right article from the King of the England. We had we said freedom, liberate, justice, and then also green peace, free from life, no discrimination for all. But in another world, in another country, in another state, let will be until now the case has reached the trial period to reveal how this case happened. The thing that is most concerning is the confusion about how tragedy happened will be moving again. Now, move about the method. We use quality approach, and then how this solve case study research by the primary data source. I do interview, documentation is okay, and always to the code, every daily work, we do that, and enthusiasm of the people in Indonesia to follow this from the news, from the media, from the TV, from the radio, and the others. The secondary data source, I got it from books, journal, thesis, and the other. And then I collect the data and data presentation and conclusion after that. So we can do this theory, how criminology said that Paul Tanneman said that the criminology is as his name. How to do to solve, and then also, same as my name, Noah Simanjunta, he also said that these cases, it must be solved from the activity and then from the real story and the witness, so that will be okay for the real time. And how to analyze this? About overcoming the problem of death and violence, the police can make effort that are expected to be able to overcome these problems with preventive and repress step by step. So that now they say shot by shot, gun by the fire, bang, 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 like the gun said. But it's the real, he shoot from the back of his head and died. That's very simple. But make it like Moses. And now, but the interesting thing here is, what if the crime was committed by parties, institution that should have taken firm action against the crime? And now, everyone in Indonesia to know this law and how to do this, to handle this, if we are make the truth of these cases for the other time. Concludes of this topic. So very interesting how this topic, when we got to find out on actually behind not this case, no person, no group, even institution can make fun or human right in Indonesia. It must be clear. It must be trusty. It must be okay for our kids, for our the new generation, our still, so that we will have the new law in punishment law, so that the conclusion of this will be the man behind the gun, the man behind the cannon, but for this day, who will be the suspect to be the man behind the gun, the man behind the cannon, but the man behind the script. This is the last speak that why it must be clear. There is no hiding area in our law in this Indonesia, in this country, in this world, because we had in green time, green life, and green condition in our activity daily, every day. Thank you very much. We back to the my hula hula.
Okay. Thank you, Pak Nelson. But it's better if you tell us a little bit about what do you mean by the mastermind or man behind the screen? You will let us know then, yeah. So now we have a Q&A session. We have 20 minutes for question and answer from our speakers. So our audience, if you have any question, you can ask directly to our speakers, and also you can write in the chat room. So we have 5 questions for the first time. Hello.
No question from this one?
The first question is from Melista Sinaga. She is a Master of Law student at Christian University of Indonesia. Silakan.
Indonesia or English?
Whatever you want.
I have a question.
Also Batak?
I think it's better to speak Indonesia.
Yes, ma'am.
Because you are Indonesian, I am Indonesia too.
I'll translate.
And you are interpreter. Okay. Related to your presentation, regarding to the events of what happened to Brigadier G, I have a question. I don't know what is the name from the Komnas HAM in Indonesia. Komnas HAM is an institution for human rights in Indonesia. Yeah. He speak as if he was a lawyer to defend Sambo as a, what is in English for pelaku? And I'm sorry. FS. FS to do. The suspect. Okay, the suspect. As a lawyer to defend the FS, but he didn't. His statement explain he defends suspect, not the victim. Related that why he speak like that. I mean, his statement embrace his position in a human rights institution of Indonesia.
Yeah,
that's all.
Your question.
Yes, sir.
Thank you.
Her question is about why the Indonesian Human Rights Commission pretending like defending the FS in the Joshua case. What is his interest on that?
Thank you, ma'am. I forget your passport name. Too long your name, Duma, yeah? Duma name, okay. One question, any other? Only one until now? Very interesting for your question. I would like to make step by step in my answer. For the first time, the lawyer of the Joshua as a victim, they make the article from Indonesian law. it must be planning murderer. After that, too many crowded. And one institution of human rights board said against by the law. They didn't say the truth because he came to the location. He asked the parents of the Brigadier G. But after they go home, let me say it at the media, at the newspaper, they standing in front of the law enforcement board, not to tell the truth. It makes me dusty cases. It means dust like the coffee, like the milk, not clear. And the last, after the lawyer of the victim of Brigadier Dead J to say something to this board that you not tell the truth in these cases. I'm not sure now they was over for their period. Okay. Maybe in the push for the powerful, and the others, we are only justified. In Indonesia trial, in Indonesia court, the judge to make the final finish, not from the board, human right like that. Not from the executor, not from the what we call prosecutor and the others. In Indonesia system court, it's only one from the team of the judges. That's the final. If there is not okay, we will make to the high level. If that is not okay, the finish, and not to be jurisprudence in Indonesia, we make to the high level. That's the board, that's the level in Indonesia. But we are not to use the words, the side of the human right board to furnish that. Nowadays, it's very, very puzzle system. In my mind, as a researcher, if died, a human being died, but the defendant, the victim, must be trial by the court in Indonesian system law. That's all I think. You satisfied? I'll be satisfied you in room. Thank you.
Okay. We have the second question. This is related to Brigadier G case. Most all dignity rights are enriched in our constitution. Human dignity protects our interests, so we need to claim it from our country. If our dignity rights are violated by those in power, for example, they had this, we cannot immediately apply international human rights dignity laws unless our relation with who has a position in law as a lawyer. The question is, what is legal entity that is obliged to protect the dignity of human rights and security at this time in Indonesia? I'm pessimistic to see that the Brigadier J case befalls us who incidentally are not government officials such as civil servants. That's the first question part. The second one is, I'd like to ask a question, but the host doesn't allow him. Okay. The first question, Constant Tibudis. One question, sir. If FS is sentenced to death by the court, can this be said to be an enforcement of human rights? Kalau FS itu dijatuhkan hukuman mati, apakah itu disebut pengadilan itu telah menegakkan asasi manusia dan setiap person? Pak, untuk pertanyaan di chat mohon untuk dibaca. Oke, let me check. Okay, two questions from the chat box. Any other question?
Yeah. I'm not sure what's question from Budi or from Andika. Raise your hand. But what's the name of the number one? Pessimistic man.
Sorry.
Okay, Edison, my hula is it. Yeah, no problem. Our hula. I'll try too many question. This one, 17 and half question. Thank you very much. Mr. Edison, I am very optimized that the sun shining from the east and it will rise to the south. It means sun shining to make our self to be growing. Your question is not pessimistic. That's our law until now, is still black and white. So that gray area, don't do like that. Until now, we believe there are three duties of the judges in Indonesia. He can to do the law, the sentence. He can to search. He can to form. In from the Professor Manotar said in his college, so that we are interested to do for this, we must be wait for the final draft and then the final finish from the court. As a researcher, I also not sure to the penalty, to the finish of this, but in my mind, and I pray, we believe to the God, we believe to the law, we believe to our constitution, and all the eyes, Indonesian people, and all the world to do this, to watch, to check what will we happen. Every day in daily walk, we are at the court, and we say Jakarta Selatan, too many witness, too many people want to do to see the white furnace Indonesia, not the black. I'm give you the answer wherever you are, not to make the gray area, but the white area for this. I am optimistic who you are to do this. If we are black opinion, all the cases in Indonesia will be black. But if we build, we will have a new law about, we said Indonesia, penalty wet book. And Dutch speaker said, KUHP will be make sure. We had democracy system. If you don't agree, you had open bar. You had the place to check to the court, to the mahkamah and the others. Not to my home, but to our board. Now again, if I am not wrong, what will the penalty for these guys? Yeah, in our regulation, in the article, let's to set the article 340, 338 article in KUHP, in our law document book, we said the planning, murder, and then the guilty must be dead or in the jail in this long time after that. And the middle and then the lowest penalty, it must be 20 years. It's the article 340. I think the others, it may be same, not to make discriminate to the others. Maybe this the question. And then the law enforcement, until now, it will be done for our activity in the court. Thank you.
All right. Thank you, Pak Nelson. Before you answer the last question for you.
Yeah.
Now we are asking audience if you have any question to our other speakers from India, from Sri Lanka, from Pakistan, or from Nigeria. Thank you.
Hello, Mr. Manota.
Okay.
Hello, Mr. Manota.
Yep. Hello. Yep. Pak Fernando.
Yes, I am Fernando. I want to ask the first answer to Dr. Anes P. Village, Cochin University of Science and Technology, Kerala, India. I want to ask, I'm Fernando Silalahi, Mr. Anes, a law faculty lecturer at the Master of Law program at the Indonesian Christian University. I want to ask about I read an article that millions of Indians have difficulty getting access to clean water because they are below the poverty line. But according to the source of the article I read, they are ethically stronger than the COVID-19 outbreak. Is this beneficial for India? Is right or wrong?
At the outset, let me tell you, it's a wrong article. It's not correct based on the data. There are some areas where water shortage is there in our country. And you know the reason. It is one of the largest territorial country in the world, and that too largest populated country in the world. And we have a particular geographical condition. We have desert area, we have hilly area, we have seashores, we have our rivers. So in desert areas, definitely they will face some water scarcity during summer season. And those who are in coastal area, there is no water scarcity or anything. So this, to an extent, there are some people, they are suffering water scarcity, but that is not because of any other reason rather than the geographical difficulties existing in our country. But the government has taken several measures. They have installed water pumps, they have installed irrigation canals, etc. So through that, the government is trying to reach each and every nook and corner of our country, and thereby they want to ensure that water supply is being provided. So that's what my answer to that.
Thank you very much, Dr. Anes, for your clarification on that.
Okay, thank you, Mr. Anes.
Udah, Pak Fernando.
Thank you.
Okay,
Mr. Anes.
we have the last question to any other question to our speakers from Pakistan, from Sri Lanka, from Nigeria, please?
Yes, I have question for Mr. Vivek.
Okay, we have one more last question. I think this question is for Mr. Simajontak, Pak Nelson.
Yes, sir.
In Indonesian like this, apakah kalau FSI itu dihukum mati, apakah pengadilan itu sudah menegakkan hak asasi manusia? That's the in English. If so, Jakarta District Court actually decide FS to death penalty, is that means that the court is enforce human rights?
Thank you, sir. From the one very, very interesting question. Let we make differences and Similarly, for the two laws from the United Nations is declaration we had its dating. It's about laws number 3399, and then our law from the penalty regulation. In one moment said we had belief in Article 10. Indonesia had, we said, the penalty death. It means hukuman mati. In frankly speaking, it's okay. That's true. In human right, if we notes, if we make from the court, that's not against the law. No, no, no. It's okay. We had the law between people, parliament, and the bureaucrat, government. That's okay. Not the law from the United Nations, but we respect for the laws. And then we had also one law and another law in Belanda said the general and the special must be equal, no discrimination. If the theme of the judges said penalty death in the hang area, do it. In the bang, 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 do it. The United Nations will be said that, okay. The second time, we said the name. Fantasiera, Mr. FS, the level head division before star 2 stars. If the judges said to the death penalty, that's okay. We are very glad. But that's not the broke our laws. But in another time, in their team, there are 2 or 1 judges said it must be 20 years in the jail as a prisoner or in his living life. That's also okay. The conclusion is what the judges said in our court. That's all. That's the rules. Thank you. We back to the hula hula.
Thank you, Pak Nelson. We then discuss it about the case after this. Now we conclude our conference.
Mr. Manotar,
We close Q
second
question and answer time. So we
Mr.
give
Manotar?
back to Catherine as MC of this conference. Catherine.
Mr. Manotar,
Thank you, Dr. Anis, Dr. Muhammad, Rafin, PhD candidate, Muhammad Kaka, also from Nigeria. Thank you so much for joining us today.
Thank you.
You already contribute a very valuable knowledge to me, to our student, also to Indonesian Christian University lecturers, and also to all audiences. So thank you very much.
Thank you.
Maybe we can clap hand to them.
Yeah.
Okay. Thank you, Mr. Manotar, and our keynote speaker. Today's event for international conference. So the first session, we have Professor Fabio Farinella, Professor Sofia Del Carril, Professor Mariano de Rosa, Professor Romina Menzo, Muhammad Abdullah PhD candidate, Rafin Tiram Vive Kanatarasa, and then Dr. Anis P. Vilai, Muhammad Kaka Ahmed, and the last is Dr. Nelson Simanjutak. Let's give applause for our keynote speaker today's event. We move on to our next agenda for appreciation from postgraduate program, e-certificate from our director, and we will give the e-certificate for today's conference. The first of all, we will give the e-certificate for our virtual on the Zoom meeting, our keynote speaker. Maybe operator can spotlight for our speaker, and then the e-certificate for show for us the e-certificate.
Everything was over. Mami, mungkin bintang satu kami. Apa syarat-syarat dan syarat profesi?
Okay, the first for Professor Fabiola from Argentina with the paper's title or the presentation is Human Rights When the Dignity Meets Technology. Give applause for Professor Fabio Farinella. And the second is for Professor Sofia Del Carril with the presentation's title is Human Rights Governance in the Americas, the Inter-American System. Please give applause for Professor Sofia Del Carril. The third is Professor Mariano de Rosa with the title The Inter-American Court of Human Rights and Its Jurisdiction. Please give applause for Professor Mariano. And then Professor Romina Manzo with the title Challenges for a Culture of Human Rights in ICT Context, the Fourth Generation. Please give applause for Professor Romina Manzo. The next one is for Muhammad Abdullah, PhD candidate with the title Human Rights and Democracy in South Asia, Theory and Practice and Pakistan. Please give applause with Muhammad Abdullah, PhD candidate. Our next speaker, Rafin Tiram Vivekanantarasa, PhD candidate. Okay, for Dr. Anes Vibilai with the title Right to Dignity and International and Indian Perspective. Please give applause for Dr. Anis.
Thank you.
Okay. For Muhammad Abdullah, PhD candidate. For Muhammad Kaka Ahmed, PhD candidate with the title Current Challenges to the International Guard of Human Rights and Dignity. Give applause with Muhammad Kaka Ahmed. And the next one. Okay, for our keynote speaker from Indonesia is Dr. Nelson Simanjuntak MSE. We would like to give an appreciation for Dr. Nelson Simanjuntak from our Director of Postgraduate Program, from Professor Bernadetta Nadeak, MPD PA, with the title The Darkness Murder Case in Indonesian Police 2022.
Thank you, Ma. Thank you. TV1 mana? Yang nyampein mertua kan ya? Oke. Sudah, sekali lagi, jangan mudah. Thank you, Ma. Oke, sukses. Oke. Fotokan, jangan udah. Aku bukan udamu. Bapak udamu. Ya. Aduh. Ya. Oke. Nanti bayaran.
Okay. Ladies and gentlemen, finally we have come to this end of this event. I would like to invite Paternus Duru to lead us in closing prayer. Before we go to the closing prayer, I would like to invite Dr. Vivi as the head of study program of Master Law to give us the closing statement for this international conference. Dr. Vivi?
Still in the air.
Yes, thank you.
Okay, the floor is yours, Dr. Vivi.
Okay, thank you very much for the Rector of Universitas Kristen Indonesia, Dr. Daniswara Kaharjono, and Vice Rector for Education and Student Affairs, Dr. Hulman Panjaitan, Vice Rector for Resources Planning and Finance, Dr. Juanifa, Vice Rector for International Affairs Collaboration and Alumni Relation, Dr. Ie Chetepu, and Vice Rector for Resources Cooperation and Development, Dr. Lisa, and then Director of Program Graduate, Universitas Kristen Indonesia, Professor Dr. Bernadette Tadea, and Vice Director of Pregraduate Program Universitas Kristen Indonesia, Dr. Desi Sianipar. Assalamualaikum warahmatullahi wabarakatuh. Salam. Good afternoon from Indonesia. Thank God today we have carried out the 3 pillars of higher education and collaboration with the Master of Law program Universitas Kristen Indonesia with several universities including National University de Mar del Plata, Argentina, College of Education, La Viaga, Nigeria, and Ikra University, Islamabad, Pakistan, the Open University of Sri Lanka, and Coaching University of Science and Technology, Kerala, India, and Magister of Law, Universitas Kristen Indonesia. Has carried out of international lecture study activity with the theme International Human Rights Conference in commemoration of Human Rights Day, December 10, 2022, Human Rights and Human Dignity, which was present by 9 researcher patients. That is Professor Romina Manso from Universidad Nacional de Mar del Plata, Argentina, Professor Dr. Mariano de Rosa from Universidad Nacional de Mar del Plata, Argentina, Professor Sylvia de Keril from Universidad Austral Buenos Aires, Argentina, Professor Fabio Farinella from Universidad Nacional de Mar del Plata, Argentina, and Muhammad K. Ahmed, candidate PhD from College of Education La Viaga, Nigeria, and then Mr. Muhammad Abdullah, candidate PhD from Ikra University, Islamabad, Pakistan, Revitram Viva Kanantarasa, candidate PhD from the Open University of Sri Lanka, and Dr. Anis Pillai from Coaching University of Science and Technology, Kerala, India, and the last, Dr. Nelson Simanjuta from Magister of Law, Universitas Kristen Indonesia. First of all, I would like to thank the lecturers and resources person, and I would not to forget to also thank the participant in the International Human Rights Conference, both offline and online, for participating in this activity until the end. Sorry if there are any shortcomings. We ask the organizer of this seminar would like to thank you for your attention. The participant, see you on another occasion, and thank you. God bless.
We will have lunch. So before that, I would like to invite Patronus Duru to give the closing prayer.
Baik, saya tutup dalam doa. Mari kita berdoa sesuai agama masing-masing. Bapa yang bertata dalam kerajaan surga, kami sangat bersyukur dan berterima kasih atas berkat-Mu pada hari ini. Kami menyadari bahwa kami ada sampai detik ini semua karena kasih dan kemurahan-Mu. Tuhan, kami bersyukur atas terlaksananya seminar internasional tentang hak asasi manusia pada hari ini, mulai dari awal hingga acara selesai. Bapa di surga, kami berdoa buat para narasumber, pemberi sambutan, moderator, yang lain yang terlibat dalam kegiatan seminar hari ini, kiranya senantiasa memberkati baik dalam kesehatan maupun dalam aktivitas. Berdoa juga buat kampus kami Universitas Kristen Indonesia, semoga semakin baik dan mampu bersaing baik kampus dalam negeri maupun internasional. Tuhan, tak lupa juga kami berdoa untuk kami mahasiswa-mahasiswi yang sedang menimba ilmu di kampus tercinta Universitas Kristen Indonesia ini. Kiranya senantiasa Engkau menyertai kami dalam proses belajar mengajar, dan kiranya setiap materi yang disampaikan dan disajikan oleh para dosen kami mampu untuk memahami dengan baik, dan kelak ilmu yang kami peroleh dapat menjadi bekal di kemudian hari dan bermanfaat bagi masyarakat di sekitar kami. Tuhan, sebentar lagi kami akan berpisah-pisah dari tempat ini. Kami mohon Engkau senantiasa melindungi kami dari tempat ini hingga sampai di tempat kami masing-masing dengan selamat dan tanpa kekurangan apapun. Hidup kami selanjutnya kami serahkan ke dalam tangan kasih-Mu. Dalam nama Tuhan Yesus kami sudah berdoa. Amin.
Thank you very much for Patronus Duru for helping the closing prayer. For ladies and gentlemen, please open your camera. We are going to take a picture.
Sudah, salam-salaman.
We have 1, 2, 3. Next, 1, 2, 3. Next, 1, 2, 3. Okay.
Wah, ganteng kali Stephen Eagle itu.
1, 2, 3.
Sama Ibu cantik profesor di depan ini. Stephen Seagal luar biasa.
Okay, thank you for all the participants.
Thank you.
I would like to say Happy Human Rights Day. May this day remind us to stand up, feel free to speak the truth, and be respect to each other.
Thank you.
Horas.
Ladies and gentlemen, thank you for joining this event, which roughly means please forgive us. And I am Catherine Monica, sign out for this event. Thank you.
Thank you.
Thank you very much.
Thank you so much.
Thank you, Hula. Thank you to Amang Boru, Nelson.
Thank you. Thank you Pakistan, thank you India, thank you Nigeria, thank you Sri Lanka.
Pak Manota.
Thank you Argentina.
Thank you.
Thank you Universitas Kristen Indonesia. Thank you Grup A, Magister Ilmu Hukum Universitas Kristen Indonesia. This is very proud of you. This is very
interesting international conference. So keep working. Thank you very much.
Thank you.
So now thank from Mr. Also point A. Point A or point A. Let me get A. In English.
Dr. Nelson, Dr. Manotar.
Kelas.
Dr. Nelson, Dr. Manotar. Good job, good job. Good job. Good job.
Thank you, Pakistan.
See you in Argentina. Argentina.
Thank you, Dr.
Ya kan gini, kita duduk orang itu berdiri biar muat.
Duduk. Nah, kalian di belakang yang kelas B.